27, if your lordship remembers that Odisha Bridge Corporation matter, vigilance matter, is rate, can it be taken up tomorrow
Let
at
us
2
see.
p.m.?
Now 2 p.m. I can't tell because
Okay.
the depending upon the matter.
Ma'am.
Once it is over, I can take.
Okay.
Let us see. Huh? Yes.
Great. My lord, criminal revision 5 of 2018, it has been listed in the weekly list, serial number 122. My lord, 22 2022 ରୁ weekly list ଆସୁଛି କିନ୍ତୁ ପଢି ପାରୁନି ଗୋଟେ ବି।
When I was waiting for lawyers to come and argue, you didn't come. And now you are mentioning what to do.
My lord, I beg pardon.
Half of the time I used to waste. I can't help it now.
May I mention, my lords?
I can't help it.
My lords, may I mention matter online?
Any mentioning online?
My lords, CRLMC, my lords, 1021 of 2024, lords were directed it to be listed on 10th July. Lords, it has not been listed. My lords, may kindly list it on Tuesday, 14th. My lords, I'll submit a memo through my associate lords.
I'm not sure whether I can take it up or not because for the board. But let it be listed. Let it be listed.
My lord, it's a very simple matter regarding the hypothetical truck being made a part of the charge sheet. 100% finance vehicles, lordship would remember.
You might have made it simple, but it's simple.
My lordship has a lot of wisdom to understand these simple matters, lordship. My requesting
Anyway.
for 14th, lordship, Tuesday.
Anyway, keep it. You give the memo, we'll try and keep it. Yes.
Please, my lords, please, my lords.
Beg pardon, your lordship. Item number 95. I am mentioning item number 95, your lordship. This is part third matter, your lordship. It required 30 minutes time. We previously learned senior counsel said I will take 30 minutes time. If possible, your lordship may kindly fix this matter on 3:30, please.
I have never mentioned about the 15 minutes. I will finish.
And you have
30 minutes. I am saying 30 minutes.
Mentioned 1, 2, 3, 4 cases, huh?
5 cases.
5
2 days,
cases.
sir.
Yes, he has said 30 minutes in each case.
My lord, this is a different serial number. I am saying 95 batch.
Okay, it's all right. It is there in the board. We'll see today. If it reaches, we'll see. Whenever it reaches, we will continue.
3:30 may kindly.
We'll continue. Don't worry. It is there on the board. It's there on the board. Yes, we'll take it up. Don't worry.
Grateful.
If your lordship will take up orders matter, then my serial will be 3. But if your lordship will take up some other matter, number 69.
1, 2, 3. 69 onwards. 3. What do you want? 69.
There's a notice to OP number 2. The last occasion before the another bench of the Hon'Ble Court, I made a mention to he is a police officer. So let notice be served with through DG police. So there is no reflection of the order.
Tick mark.
Because he is going on transferring.
Tick mark. Remind me when item 3 is taken. I'll do that. Don't worry.
Much obliged.
Yes, next. Come.
Only notice be they must have the
notice matter through police served on the OP2.
Let it come. He has mentioned it. I note it down. Don't worry.
No. The
we'll make sure that service is.
Notice is not sufficient, but you should serve notice through
yes,
it.
Call. Don't be spent. Yes.
Hey, salary. Oh, that it's then my answer is sufficient.
Sufficient.
Yes.
Then 1.
Item 1. Yes. And before I start, where is that list? See, Mr. Ragada and Mr. Das also. See, we have we have taken out these matters about.
I'll take instruction on all the cases.
No, I'll pass a common order because these are the appeals and revisions, old revisions. I'll pass an order to the concerned police stations to get the whereabouts and well-being of all the petitioners. Whenever you get the information, in whichever matter, if somebody has died, you please tell me so that I'll take up that matter and finish it up. Otherwise, these matters will never move.
All the cases free copy will be given.
All the matters free copy. Today, I'm passing orders in all about how many matters? 20, 30 matters. 20, 30 matters. I'm in all the these revisions.
All the copies are
all revisions. Yes.
But I'm sorry.
Yes.
Yes. May I please, your lordship. Your lordship, passing of the FIR and criminal proceeding.
Yes.
Initiated against the petitioners, your lordship.
Yes.
And there is a case and counter case, your lordship. Earlier, the petitioner filed a case against the
mediation report received, but can't see the mediation.
My lord, it was referred to mediation, and thereafter they created trackers in the mediation proceeding. And thereafter
has been registered. As a result of which this CRL which has been issued.
These are matrimonial disputes.
Your
No,
lordship.
my lords, this is a family dispute per se between the mother-in-law and the daughter-in-law, my lords.
Then you have decided to fight it out. Go and fight it out. I'm not.
Your lordship, fraudulently.
I gave an opportunity to you to settle the
Fraudulently,
dispute.
they have got another
My lords, in
legal.
the court premises, my lords, this
Already they have
education has
completed
come up,
the
my lords.
DLS,
The DLSA proceedings was going on. They created a
Where
ruckus.
is that report?
This is the FIR, my lords. The impugn FIR is item 1, my lords.
Already they have
The same
completed.
FIR.
Show me the allegation. Where is that allegation? Read
My
this.
lords, they have not served a copy till now, my lords. It's coming up for the first time.
I have
It's
not
not
served the-
before notice matter, my lords.
Okay, I'll pass the order. Okay, next. I'm dismissing it. Okay, next. Both the matters I'm dismissing.
All right,
Grateful, my lords.
all right.
If people opportunity was given to you to settle the dispute, you don't want to settle and keep on fight. Okay, next.
Both get disputed.
Both the get dispute. Yes. Two.
In this
Yes.
case, madam, it's not challenging the order passed. Trial court allow the 311 person, which is challenged.
Allow the petition.
Yes, madam,
So who are you?
for the accused person before the trial court.
So is allowed, whose application 311?
PP filed the application.
FPP there, my lord. And that have been allowed, my lord, in 6/8/2023, my lord. For the IO, my lord, 2 questions, my lord. That must have been completed, my lord.
Right now.
No, madam, not
By impugn order
Are you-
dated. By impugn order dated 16/8/2023, the Court of Assistant Sessions Judge come Special Judge First Track Baleshwar in ST case number 3/31 of 21 has allowed the application moved by the prosecutor for recalling the IO for the purpose of posing 2 questions.
Two questions.
Two
One,
questions.
my lord, that
Two
is
questions.
paragraph 2 of the reason. my lord.
2
It was allowed.
questions. And the and pulls up. The petitioner being the accused is agreed by the said order, therefore he has filed the present petition. And since the impugn order was passed, Vivek in impugn order is passed on
16/8/2023.
16/8/2023. A year has already passed by now. I'm not inclined to interfere in this matter. Moreover, there is no legal infirmity in the impugn order. Hence, the petition is disposed of. Next.
Now, after it, he has not already examined.
Yes. Next.
Item 3.
Don't delay. 3. What happened?
Let's see, kindly pass over.
No. 3. Mr. Das was appearing, na?
Let's see.
Sorry, Mr. appearing. Same matter?
Passing, my lord.
Huh?
Yes, 69.
69. Okay. Yes.
Here, my lord, passing of FIR and 36 kg, 400 grams of ganja recovered. Thank for pass.
Why quashing? Investigation is on.
My lord. Is it not
Absconding and you, what is this?
passing of FIR?
What are the grounds? And only a FIR copy is filed. And quash it. Write down. It is seeking, in this petition is seeking quashing of the FIR number so and so, registered against so and so. It is seen from the record that there is a recovery of
36 kg, 400 grams.
36 kg, 400 grams of contraband ganja. The investigation is still going on. Therefore, at this stage, I am not inclined to entertain this petition. Hence, the same is dismissed. Yes.
The 4.
My lord, question of cognizance, my lord,
Yes.
for 24/68/471, my lord.
Who is there? Odi. Notice was issued. None appears. Last time also no
Last time the
appeared.
lords was directed to file the charge sheet, copy of charge sheet.
Petitioner is seeking passing of cognizance of so and so. case. Our copy of charge sheet has not been filed. So charge sheet now filed?
No, not filed.
Password करो. नहीं आएगा तो last time nobody had appeared also.
Yes, my lord.
Yes, password करो. Yes. Yes, sir. What is this matter?
My
711.
Challenging the rejection of 311 petition, my lord. Sir, please.
Is there? Notice was issued? No. He's seeking
Seeking recall of.
recall of which witness?
PW
PW 1, 2, 3,
6.
4, everybody, yeah?
3-6.
Offense under section so and so. Where is nothing. He is not filed also. It is but a prayer is for recall of it. 302 efficient on report from so while dealing with the four issues release file. Your direction to expedite the trial and they complete it as soon as possible, preferably within 6 months. The defense counsel also has knowledge of the time bound to the case, but prayer for recall of witnesses to be so to the plea of examine them. Personally, the auto sheet so and so to be the PM from examined by the court on those days and hearing to place in presence of this court has given a direction for time-bound disposal of the case.
Expedition.
And they were given opportunity. They didn't cross-examine. Now moving application for the purpose of recalling all the witnesses.
Yes. Under the section
Pass on.
303.
Item 6.
Passing of order taking cognizance is under challenge, my lord. The main point is there is,
Show me the charge sheet. What is the allegation?
my lord, page 15. Page 15, may I kindly have a glance.
Place
Page 15
15. Okay.
of the charge sheet.
Yes.
Received information from release a huge quantity of explosive substance are dumped in northern side of partly construction base camp near village so and so. On receipt of such information, he arrests 2 independent witnesses, namely so and so, and proceeded to the base camp partly on information and conducted a raid. During raid, they found explosive substances, materials such as basing on the report, the then IC restored PS case. The spot has been visited, explosive materials. And main,
Cognizance of the year 2018.
and the main point is there was no valid sanction, only the cognizance was a sanction, but there is no valid sanction.
See what kind of crime. You see,
That is
much more dangerous than murder, whatever you say. See the kind of explosive. And I think you are a terrorist. You designed to kill many people.
not terrorist.
Withdraw it.
Withdraw to file discharge petition. Withdraw
The
to
counsel
file.
for the petitioner seeks to withdraw this petition to avail the remedy under law.
And to raise all the
appropriate-
points.
Appropriate stage before the and liberty is granted to the petitioner to raise all the points before. But this is don't explosive, so much of explosive.
I have seen that.
The design is to have a
Supply this
attack, no?
explosive to the Naxalers.
Ah,
No, no,
it's
no.
very
That
dangerous.
is not, that is not on record. What?
But you see the recoveries.
Why has he kept this as explosive here?
They should not get bail also. This kind of thing. Yes.
Item 7.
Maybe, Lords. On behalf of Mr. Sahu Millers,
Yes.
I'm challenging the order of cognizance, Millers, at page 9, Millers. Millers, on the ground that all the cause of action arose in Hyderabad, there is no jurisdiction.
Where is the charge sheet, sir?
Well, charges
Not
are-
the charge sheet.
Yes,
sir.
File the charge.
My lords.
1 week time is granted to the petitioner to file the charge sheet in the present case. Yes. You file the charge sheet.
My lord,
How
my
will I test the cognizance? Yes. Next.
Okay.
Item 8.
The petitioner challenges the order dated 13/1/2020, my lord.
NBW?
Yes, my lord.
Tell me, when NBW?
13/1/2020.
13/1?
20 lordship,
20.
4 years back. 4 years back, the order is
If you are not executing the NBW, you should have executed. He is coming voluntarily. You didn't appear, huh?
Yes, my lord. Time petitioner filed, time rejected, the warrant
The
is.
petitioner is agreed by the order dated 13/1/2020, whereby NBW against him is has been issued by the court below while rejecting his application
Time petitioner.
seeking adjournment. Letter counsel for the petitioner on instruction submits that his client would be appearing before court on 30th of this month,
Yes,
Yes.
31st of this month.
302 lordship.
And
302 is there.
sorry,
302 lordship.
whatever, appear before so and seek remedy under
Yes.
law. Regarding to the submission made by the petitioner, the NBW, the impugn order dated 13/1/2020 passed by Eri J. Kujongo in CT case number 90 of 2015, issuing the NBW against the petitioner shall be kept in abeyance till 31st August subject to the petitioner surrendering before the courts below.
Lordship say
On or
appear.
before
Lordship
31st on or before 31st of August and subject to the petitioner paying cost of
appeared, not surrender, appeared, my lordship.
surrender oblique appear, and subject to for further condition that the petitioner shall pay rupees 1,000 to the welfare fund of High Court of Orissa. Yes.
Page 16 is the affair. These are minor offences. 294.
Watching.
Yes, 294, 354, 506. My anxiety is petition number 213. Petition number 213 are the grown-up daughter of petition number 1. They have been implicated in a case on 294, 354, and 506. If a lordship will kindly see the affair.
One.
No, 213, petition number 213 and a daughter of the petition number 1. One is 27 years, one is 20 years, marriageable age.
They're not minor.
Yes.
Okay.
No, marriageable age.
Marriageable.
Only minor offences have implemented the informant as opposite party number 2.
What are the allegations?
Allegations,
Come
Lord,
just.
informant's husband was attending call of nature in front of my house.
Informant. Then
These petitioners abused, as per the affair, abused him in filthy languages. This is the entire case.
in court report witness from her husband attending the What do you say? See,
Yeah, and for that only I have not.
That's why I have implemented the informant as opinion number 2. Yes, that's why.
if you notice, are you on bail?
Malak?
Are you on bail or not? You got the bail.
I am on bail. That is the case. I am on bail.
Next week, you put it, leave this week, next week, and sir, we'll see. We'll pass it.
Oh, ସେଇଥିପାଇଁ କହିଲେ
bring-
ଦିଟା grown up
bring
ଛୁଆ
him-
ଅଛନ୍ତି ସେଇଥିପାଇଁ I only for that.
Small misunderstanding.
Yes, small understanding. She is also interested for solely.
Issue notice and bring him. Yes.
Item number 3, your lordship might have, I have written item number 3, I couldn't reach in time.
I also noticed maybe so.
IAB. आपको
Item number 3, I couldn't reach in time, Lord. I'm sorry. Can you tell, take a little matter, take it?
I passed that or let us see. I have already passed some of. Yes. Next.
Item 10.
Yes.
Draft case, the revision is against the order in a draft case. Demand was for 80 lakhs, 80,000 for passing of Chatua bill of rupees 11 lakhs.
Charge has been framed.
Charge has been framed.
Against that, yes.
Yes. And in fact, this is one of the very few briefs I have received, which contains almost everything. Charge sheet, 161 statements, the decoy also stated at page 124 that what was the prior demands and the demand on this spot. And the
What
demand
is the
was.
ground then? What did he say?
I expect my Lord's senior to
Right now.
pass it.
Pass it over. Pass it over.
Mr. Mundul.
Item 11. Item 11. Let's kindly be taken out next week.
What is this matter?
Matter, let's say, the challenging the.
This case also stand at par with that one because this is a revision against an order framing charges, my lord. But this is again a trap case demand of 10 lakhs. And my lord, a vigilance inspector is involved. And my lord,
You don't have a case, why are you asking for
the
it?
petitioner is the vigilance inspector, my lord, demanded 10 lakhs.
You are supposed to
In fact,
raid people and you are.
yes.
Anyway.
Next week.
I'm adjourning on request. Let it be adjourned. Let the trial start, then that will be in practice.
Only
Yes.
that's it.
Item 12.
Adjourn. You would adjourn. Last one. Time name. Yes.
Item 12.
Yes.
Offense 25 number item, data both are.
Offense.
Offense 20 with USC of the NDPS.
You don't come in small offenses.
Yes.
You never come in small offenses. Whenever you are there, it must be very heinous and.
No, 20 with USC of the NDPS Act.
What I'm submitting, my lord,
12,
let item 12 may be taken over the time. She's saying, lord, CD is available item 25, my lord. Let be taken up.
Okay, 25.
Mm.
25.
Data file ಲೆಕ್ಕ ಸಂಗ್ರಹ
25 and 12.
My lord.
12.
Both are accused in
Both
the
are
same.
two accused persons
Okay,
are alleging
see.
out of sun.
25 is the class of the court. Yes. Next, 13.
13.
My lord, the petitioner is a 71 years old man, my lord.
What
My
is
lord,
the offense?
452, 372, one of the IPC, my lord.
376.
My lord, 71 years. My lord, is custody since 17/9/2023, my lord. 9/2023, my lord. And
Okay.
charge sheet.
What is the allegation? You say?
Allegation, my lord, the petitioner committed rape to the daughter of the informant in the dwelling house. My lord,
What
this is
the victim says?
victim is 22 years, my lord.
164 statement is there, my lord.
Read it.
My lord.
My lord, the
1 minute.
total.
1 minute. Yes.
ମୋର ନାମ ସଚାନ ସଚ ବୟାନ ଏଇକି ଯେ ଶୁକ୍ରବାର ଦିନ ପ୍ରାୟ ଦିନ ମୋର ବୋଉ ବ୍ୟାଙ୍କ ଯାଇଥିଲା ଗଙ୍ଗା ପିଉସା ଦି ପିଟିସନର ଗଙ୍ଗା ପିଉସା ମୋ ସହିତ ଲାଗିଲା ତାପରେ ସେ ଦାଣ୍ଡ ପଟେ ଆମ ଘର ଭିତରୁ ଆସି ମୋତେ ନେକେଡ made naked and thereafter the slang language committed directly stated that
What happened the
the
present?
overtake attributed to this?
So far present petitioner is concerned is being a lady having no active
lady.
participation in the alleged crime, your lordship. That is my submission.
Yes.
And here is
1 minute. 1 minute.
That's it.
What are the allegations?
my lord allegation so far against the petition is concerned, my lord. What happened in this case, my lord? There are, my lord, the accused persons, the husband and son of this petitioner, my lord, they committed murder of 4 persons, my lord.
No.
Wife, husband, this is person, my lord, this wife, husband, and their son and my lord, the daughter, my lord. In a pre-planned manner, they have committed the murder, my lord. Though the my lord, principal accused was been arrested, my lord, the husband of this my lord, the lady petitioner, he has expired while in jail custody. And son is alive, he is also jail custody. This petitioner also arrested in connection with this case. His role, my lord, though it is a cold-blooded murder case, my lord, what happened in this case, my lord, this lady also involved in this case as because he guided the room where they one after committed murder and kept the dead body in the room, my lord, he guided the room. And here this petitioner very much present there and guided the room. Thereafter, my lord, what happened? He also, my lord, the সেটা যে blood সব পচিয়ে দেবে সফা করে দিয়েছি she is also there, my lord. These are allegation against all, my lord.
Four murder.
Sure, that's right.
This lady will release her bail, my lord. Nobody there to look after her, my lord. And the charge are already been, last occasion your lordship asked my friend to take his charge are already been failed, my lord. the summons issued to the witnesses.
You revise your bail application.
Kindly glance for a moment the affair, Your Lordship. Your Lordship, that is due to long civil dispute between the parties. They, right. So far present, I am not disputing that the.
Present there, my lord.
Anyway.
So far present petition is concerned, what is the role? Your Lordship, kindly glance for the moment the affair allegation, Your Lordship, first. Here, what happened? There is a long civil dispute.
Charge sheet has been filed, charge has been framed, and the allegations are very, very serious. 4 murder committed by your family. The entire family is eliminated. What are it? Right. I am not inclined to enlarge the petitioner on bail at this stage. However, the liberty is granted to petitioner to renew the bail plea after the material witnesses are examined.
That's my, so my.
Submits that charges have already been framed. And how many material?
Yes, Your Lordship. That's my kindly observe in Your Lordship's order.
All total, my lord. All total, my lord. 28 witnesses, my lord.
28.
My lord.
Material.
Who those are who's?
My lord. Except official witnesses, my lord, all the witnesses are my lord.
And that's that. Your Lordship, may.
It is expected that the trial court should see that the material witnesses are preferentially examined over the formal witnesses.
Within a period of Your Lordship, kindly fix the time limit, Your Lordship. Then therefore I will renew my prayer. Present petitioner is concerned.
If
the being a lady.
Okay, if the petitioner can also renew his bail application after expiry of 6 months, if the trial doesn't proceed at an expected pace.
Obliged. May I please? 498 304B 302. The present petitioner is the husband, my lord, and he is in custody since, my lord, the date of his arrest, that is 36/2023.
36?
2023. 36. 36. 36/2023.
Okay. Yes.
And
what are the allegations?
Allegations are omnibus, my lord. Only the material against the present petitioner is the cause of death of the wife. The cause of death, as per
How she died?
Yes, my lord. That is, I am coming, my lord. That is, asphyxia and venous congestion could be possibly due to some external force up over the neck. That is the only material against the petitioner so far as the PM report is concerned. Otherwise, all other allegations against all of the family members are omnibus in nature.
But there is a ligature
mark, my lord.
Mark.
Ligature mark, no?
Chastity, my lord.
Strangulation.
Chastity, my lord. Chastity, my lord.
Strangulation.
From the chastity, my lord. The asphyxia, venous congestion could be possible due to some external force applied over the neck. Further examination, viscera has been preserved, my lord. And that is, my lord,
how will you get out?
Extra force applied over the neck.
Only custody period is there. Apart from that, there is no.
Other people, other family members are
on bail.
They have applied for anticipated bail and direction given.
Yes.
Anyway,
they were released on bail.
They are entitled.
Yes.
But there is
this petitioner, since the husband, my lord.
Strangulation. That's the problem. What is the stage?
Lordship may target the trial.
Stage.
Stage, my lord, the charge sheet has already been submitted.
Charge has already been framed.
Then how many material
witnesses were 18.
18.
18.
No,
total witness.
Total witness.
Material, you tell me.
Material witness again. तांको family member और doctor. तो family member होले 6 जन, doctor एक 7 जन. बाकी वो अन्य माने सब
6 months same order कर दी. हाँ. Same करो ना material witness. And over preference should be given and 6 months.
But if not, liberty may be.
Liberty have been.
Obviously.
16.
It's at item 16, praying for 2 weeks of time, let's say, due to some personal difficulties.
Urgent.
17, what happened? 17 item, my lord. There are, my lord, the 5, my lord, cases, my lord. All the cases, what happened is case one, they adjourned to
23
23, 8 and 24.
yes sir 23 ଟା ଖାଲି ଯାଇଛି ଗୋଟେ ଆକ୍ୟୁଜ ପାଇଁ ସେଟାକେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ପକେଇଛନ୍ତି
23
ସେଥିଲାଗି 23 କୁ ଯାଇଛି
ଗୋଟେ
23
ରେ take up. My lord, in this matter, my lord, the connected matter, second item, my lord, 13607. In that matter, he has filed an interim application for interim bail.
Verify that.
My lord, what happened? We have already verified. He stated that now his condition is not good. Your lordship directed you supply the medical
I
documents.
already supplied that.
What medical documents he has supplied? That is 4 months, 5 months before.
medical
This is a medical document. So only he has given only he has given a prescription.
Treatment at the jail ରୁ କଣଟା ପାଇପାରିବି?
Only my lord.
It is undergoing treatment.
No.
Jail treatment.
Yes, my lord.
Only I have taken
From the jail,
only I have written the superintendent of jail, my lord, that is provide the instruction that what is the health condition of the present
You
prisoner
get that info.
without referring any document, my lord.
Right.
But he was earlier in Bisam Katak jail, my lord. I have written, they replied that now the prisoner is transferred to Gunapur jail. So I have also written letter to the Gunapur jail without referring any document.
You get because he
Only
is
health
under
condition
under the jail treatment.
Yes.
So therefore you get instruction from the jail. Why should you depend upon the
Yes, my lord.
documents?
My lord. Earlier I have written to
23rd, the other
23rd
matters
course.
are coming.
In
All
the meantime, I will
you
bring.
get it.
My lord. In the meantime, I will.
23rd. Okay. next.
For electoral 1899 and 1903, I am filing the wakalat now.
No, you file. File. No. Yes. Take file in this. 18.
Item 18.
Kindly take number 1 week after. In the meantime, I will take instruction the status of the trial, my lord.
Adjourned. Yes.
19.
September. Yes, 19.
20 minutes.
19. 19. Yes, sir. 19. What is that?
376. CD is available.
164. Read.
My lord.
Read 164. If he is entitled, whether he appeared or not, how does it play? Entitled will give, otherwise adjourned. 164.
My lord, I read out. A long ballad.
Consider again 50 years.
Any page.
Relevant part. You not.
ବୟସ ଦର୍ଜନ ମାର 6 ମାସ ବୟସ ମତେ କହିଲେ ଆଉ ଗୋଟେ ଲୋନ କରିଦେବ ରିଲିଭେଣ୍ଟ ପର୍ସନ ପଡୁଛି ମତେ ଘରକୁ ନେଇ ଗଲେ ସେଠା
Worked and 66 of IT Act, along with other 22/8/2023, my lord. 2023, my lord. I have annexed, my lord. I have
23.
My lord. I have filed the deposition by my flag T.
Yes.
My
Read
lord.
it out.
My lord. Yes, it is filed, my lord.
Statement is also recorded.
My lord. Yes, my lord. After the 6 years of relationship, my lord, he has lost the affair. Incident also, my lord, in the year of 2017 and 2015 between.
Show me where is that?
In flag T, my lord. Flag T.
T,
my lord. Yes, my lord.
T, okay, flag T, okay.
Yes, ma'am. The incident took place on 21/8/2023.
Incident took place on 21/23 at about 5 p.m. in my house. In the year 2015, I was studying in close to.
They are studying both in college, my lord.
College.
Due to some caste dispute, their marriage did not happen, my lord. Because of that, the affair has been registered, my lord.
For which he used to cut his hand. This is a love affair.
My lord, love affair.
She was minor by the time.
At the time, she was minor, my lord.
He is also minor.
He is also minor. At the time, he was
Both of
19,
them
my
are
lord.
minor.
My lord.
Both of them are plus 2 students.
My lord, plus 2 student, my lord. At
They
the time of
were
incident.
in love, and he cut the hand also.
And also neck.
Neck also, this boy.
Because of my lord, due to my lord, they have not as.
They failed away, they remain somewhere else. They are
My lord.
Forget.
My lord.
Don't spoil the life of children. Right now. Petition rejection is also. And he is in custody since 22/8/2022. The trial is going on this matter, and the victim has already been examined by the examined in the trial court, who inter alia has stated as under para 2 and flag B. Para 2 and flag B. Para 2 court. You are कितना it is an admitted fact that the petitioner and the victim were in love relationship. Both of them are minors. Since the evidence has already been recorded, and the petitioner is already in custody since 22/8/2023. I'm inclined to enlarge the petitioner on bail accordingly.
Definitely, much appreciated.
Yes.
Please. The last occasion also directed to verify the record, that's it. Whether the video clip or mobile phone have been seized or not.
Yes.
The forwarding report also it has been mentioned clearly. And the charge sheet also it has been mentioned. The mobile number, the Redmi mobile phone having EMI number so and so of the victim, which was used by the in this case has been seized from the possession of the accused. Thereafter, he has been
Married lady, madam.
married lady,
Married lady.
person also.
ମତେ one
Petitioner
second
also
ମୁଁ
person.
ଜଣେ ବିବାହିତ ମହିଳା, ମୋ ସ୍ୱାମୀ ମତେ ବହୁତ ବାଡାପିଟା କରିବାରୁ ମୁଁ ତାଙ୍କୁ ଛାଡିକି ଆସିଲି। ମୋ ବାପ ଘରେ ରହୁଥିଲି। ବିକାଶ ଦାସ ପିଟିସନ ନାମକ ଏକ ବ୍ୟକ୍ତି ମୋ ସାଙ୍ଗରେ ମୋ ସାଙ୍ଗକୁ ଠାରୁ ନମ୍ବର ଆଣି ମୋ ସହ କଥାବାର୍ତ୍ତା କଲେ ଓ ମତେ କାମ ନେଇ କହି ମଙ୍ଗଳାବାଗରେ ଏକ ରୁମକୁ ଆଣିଲେ। ସେଠି ମୁଁ ତା ସହିତ ରହିଲି। ତା ସହିତ ମୋର ଶାରୀରିକ ସମ୍ପର୍କ ରହିଲା। ଆମ ଶାରୀରିକ
20 no 13/12/2023 madam.
13/12/2023. 23.
Madam.
Give that statement. 164 is recorded.
Yes ma'am.
164. This you read it at 164. Give that I give. 164. Give that portion. Give that. And the investigation has already been completed. Charge sheet has been filed on. Charge sheet filed on.
Charge sheet on matter.
Charge sheet filed on
3/4/2024.
This statement of the prosecutor was recorded under section 154 the RPC. She internally has stated that she has been tortured by her husband. In the husband, the accused become friendly to her, and they started staying house. And during that point in time, they had a physical relationship. Spiritual. She internally alleges that during her physical relationship, the petitioner has taken made videography, and subsequently he has been threatening to viral the video. Therefore, she has filed the FIR. Video. What about the mobile phone? The Mr. Raghural and Council for the State submits that the video, the mobile phone has already been seized. The charge has been framed. Charge has been framed. No.
Yes madam. Case has been committed to the court of sessions.
Charge has already been framed. Case has already been committed to the court of sessions. Having regard to the aforementioned submissions made by the council and the period of custody of the petitioner from 13/12/2023. I'm inclined to grant the petitioner on bail with the condition that the petitioner shall appear before the court without fail on every date of hearing, and he shall not be in communicate with the victim in whatever manner whatsoever.
Obligation.
Violation of any bail conditions shall entail cancellation of the bail, and the prosecution is given liberty to move appropriate applications before the trial court in the event of violation of any bail condition for cancellation of the bail. If such application is moved, the trial court is at liberty to decide the application on its own merit. Yes.
Obligation.
So that you need not come here, go to the trial court and get it cancelled. Yes.
Lordship, I have moved an interim application in Lordships to release the petition interim bail, my lord.
What happened to you?
Lordship, it's a dispute between real estate developer.
No, interims.
Yes, my lord. Lordships, may kindly see page number.
You are sure that you won't be getting regular bail?
Lordship, I'm sure of that. But the fact is, my lord, on the last occasion when
You tell me if you are entitled to regular bail, forget about the interim.
So also they are in the process of settlement with the deposit home buyers.
What is the
Offense under OPID Act, my lord. The offense was regarding the dispute between the real estate developer and the home buyers that resulted in filing of the FIR, my lord.
You are a developer.
Yes, my lord. Real estate developer. Offense under 6 OPID Act, my lord.
How many cases are registered against you so far?
So just one case, my lord. This is the only case.
How many complainants?
Complainants, my lords, 161 have been recorded by 3, including the informant, my lord. Apart from that, no others, to my instruction, no other persons had come forward to register their 161 statements, my lord.
How many from how many people you have taken?
Lordship, as per the, they are spent there 35.
Copy Millers, 35 investor, 4 crore, 80 lakh has collected.
Lordship, out of that 35, we have already refunded 5. We have deposited 50 lakhs before the learned OPID court, my lord. Just the only difficulty what happened in the next 3 months, my lord. We are not allowed to operate our bank account. That has been seized by the UOW. And next time, lordships, we could not register any, we could not sell any land because there is a halt in the registration process, my lord. We are in the process of negotiations. They are ready to negotiate with the developer, my lord, and they have agreed into a terms of settlement. That's why also praying 3 months, just that 6 months time, so that we can settle this matter. It's just a dispute between the registered developer and the home buyers, my
At a glance, order dated 6/5/24, my lord.
6/5.
Yes, my lord.
It is categorically mentioned, my lord. Petitioner deposited a sum of 50 lakh before the court in session over the matter at the time of his release on interim bail. The balance amount out of the total amount of the alleged fraud amount to be refunded shall be arranged by petitioner in the meantime. So in the meantime, he has not refunded a single money, my lord, to the petitioner. And further development is that, my lord, the agreement between the petitioner company and the private person that has been cancelled, my lord. Now he has no land to give, my lord. So flat posting is ready to hand out flat, my lord.
Bail was granted to you.
Yes, my interim bail was given, my lord, for 3 months. In the meantime, I have already tried many attempts, like so the bank accounts have been freezed, my lord.
Matter to be listed on 9th, my lord. It has ordered to matter 9th August, my lord.
So where from what is your source now?
This sort of
Will you
source
comply
is-
this order if I extend for
Yes, my
another-
lord. We'll comply this order, my lord. We have already, there is schedule of repayment that we have agreed
Show
with
me,
home.
show me. See, the problem is if you put him in the
Exactly, my
inside
lord.
the, jail, where from he'll arrange
Exactly,
money
my
give
lord.
these people.
We want to refund, my lord.
That is another flip side of it.
We also want a solution.
Out of 35, he has not paid a single.
What I'll do is I'll extend for 1 more month.
Lordship.
If he doesn't do, I'll make it a preemptory thing.
Lordship, what I'm praying, my lord. Let it be 3 months. It doesn't bring, my lord.
You show the at least you
Lordship.
give to few people, I'll extend it.
Bilkul.
Not
Lordship,
that,
Lordship, Lordship, what I'm praying, my lord. Just a small prayer, my lord. 50 lakhs have already been deposited by me before the learned court below, my lord.
Don't make court to a party. You have
We're not
got the
thinking-
bail, some condition was there,
Yes,
you
my
have
lord.
complied.
My lords, they are saying, lords, may I read, my lord? That or part of
No,
the
I
order.
don't want. How much time you need to?
Lords, 6 months might.
No, 6 months.
3 months, my lord.
No question of extension. One
Lordship,
month, you 1 month to begin with, I'm extending for 1 month.
Lordship.
Come and pay the money little bit at least.
Lord.
So something.
Lordship, what I'm praying, my lord, 3 months, I will.
1 month, I'll reduce to 15 days if you argue further.
This 2 months.
You got the order from the court, you don't comply, I'm giving 1 month.
Your Lordship,
At least settle with 1, 2
At
people.
least, I'll do that. I'll do that, my lord. I'll do
Yes,
that.
show something.
I'll do that, my lord.
Right on. Something. By the order dated 6/5/2024. The coordinate. By the way, one more thing. If the coordinate bench has passed this order, how can I extend? And why should I extend?
Yes, assignment has changed, my lord. That's why it has been listed before, my lord.
Ideally, you go to that court. It doesn't.
That's my predicament is that he has
I'll direct to list it tomorrow or day after anytime.
grateful, my lord.
Then next week.
No, Lordship, let it tomorrow, my lord. Because
Let it be tomorrow, no.
Millard.
Because that court has passed the order.
Millard.
Why should I extend time? It's not fair. Okay, right on. By the order it is 6/5/2024.
Not been disposed of the lords, you can, my lord.
Yeah, but let it be. I don't know what transpired there. He must be knowing better than me. And so, huh? So then.
It has originally adjourned to 9th.
6/5/2024. The coordinate bench of this court has enlarged the petitioner on interim bail with various conditions. The condition has apparently been not complied with. Therefore, he seeks extension for time. Since the coordinate bench has granted the interim bail, I am not inclined to intervene this petition. Let the application be listed before the same bench, subject to the permission of the Honorable Chief Justice tomorrow.
Grateful, my lord.
Yes. Monday. Let it be Monday.
That's lordship. The problem, lordship, if I don't get the order in time, my lord, something happens. So tomorrow is 9th, my lord.
My Lord Chief Justice is not present. Therefore, I'm saying. Monday. Today is not holding the court. Yes.
Grateful, my lord.
3 to 2, my lord. One time maybe give 7 day time. CD not happening.
No CD. Call for CD.
Next week I swear February file kali.
Awaiting CD, huh? Urgent.
Next week है lordship में से.
Give a date, don't worry. Yes. Yes. 24.
Yes, the person in custody since that 14/7/2023, my lord. 14/7/2023. The date of occurrence is 13/7/2023. Date of occurrence is 13/7/2023.
Okay. What are the allegations?
30234 IPC.
Okay.
There is no eyewitness to the occurrence.
CD is there?
Yes, ma'am.
There is no eyewitness to the occurrence. Entire case is based on circumstances. The deceased was in along with the one Milan, my lord, since last 2 years. He is living at Chennai, working in a private farm. He got information that the victim is having affair with somebody in his absence.
He came and killed.
He came, and on the date of occurrence, the man accused Milan, one present person, another. The three had been to the house of the victim.
Yes.
There was altercation between Milan and the accused, which leads to
Milan had relationship with the
the.
What are you?
So in course of investigation, Milan was arrested, and while in police custody, confessed to have committed the offence.
You have said that your age is 18 years.
My lord?
Your age is 18. You are minor. Less than 18 or 18? What?
No, major, major. No, yes, yes, my lord. Affair 15 years.
Juvenile?
No, I am not juvenile. The victim, my lord. You also see.
No.
Only
in the court title you have written your age is 18 now.
Yes.
So when the incident had taken place?
It was in 2023, my lord.
So therefore, I am asking.
No, not juvenile, man.
Then why have you written 18? The time of incident, you must be juvenile. Verify this.
Yes, I have not stated. My petition is not there, my lord. Item.
Jitu Rana. You are from Jitu
Yeah,
Rana.
Jitu Rana.
You have written Jitu Rana, age about 18 years.
Yes.
This petition is filed in 2024. Incident has taken long back.
2023, yes.
Then that time, if this is to be believed, then you must be a juvenile. You will immediately be out. Verify it. I'll put it next week.
As you also.
25. Whether he is juvenile or not, get some certificate so that you will be out. Yes. Next.
25, my lord. Item number 12 and 25. Both are arising out of 71 PS.
Yes, sir. Mr. Ragada. Where is Mr. Ragada?
Mr.
My lord. You were there. Yes.
My lord, 150 kg of ganja. Two accused persons. They are in custody since, my lord, 13/10/2022. 13/10 October. 13th October 2022. Recovery, my lord, from them 150 kg.
Cross 100.
I got any about
150 kg from exclusive possession from the.
ଗୋଟେ ଗାଡିରେ ଥିଲେ 2 ଜଣ ଯାକ young person ରହିଗଲେଣି
ବର୍ଷେ ତ
ବର୍ଷେ 10 ମାସ ହେଲା ଅକ୍ଟୋବର 2022
October, right? You are in 22.
22.
Okay, I thought 20.
October,
What is the stage? About 2 years, Elani?
My lord, charge sheet has been submitted.
Charge sheet submitted.
Submitted on 3/5/23, my lord, 29, my lord. Perhaps a trial may be started, perhaps has been started. My lord.
Within 6 months, you don't, then
Six
I'll
months.
give.
My
6
lord,
months.
trial matter commenced in the meantime. 4 witnesses matter are only examined.
That's what I'm
Out
saying.
of
Within 6
19
months, if it
witnesses.
is not completed, then you are
My lord,
entitled. I'll record that. 150 kilo. 6 months I'm giving you that.
6 months is both ages. Yeah, charge you
How many witnesses are total?
My lord, total 19 witnesses out of some of the seizure or some other witnesses are there. More 4 to 5 witnesses have been examined so far. So,
In these kind of cases, everybody is a material witness. In this kind of case,
similar
only
किसी
official
का
witness.
decline है ना सब तो देबे ने किसी decline ही जीवे 4 मास था
4 months, huh?
Yes,
4 months. Because see, about 2 years.
2 years.
And petitioners are in custody since a petitioner is accused in such case. Charge sheet has already been filed. Trial is progressing. Out of total evidence,
19 witnesses.
19 witnesses.
Charge sheeted witnesses.
Charge sheeted witness about
exactly information is 4 to 5
about 4 to 5 witnesses have already been examined as examined. The petitioner are in custody since the 13/10/2022. Regarding to the fact that the petitioners have already in custody about 2 years, and the trial is not proceeding in the expected pace. I'm although not inclined to enlarge the petition on bail in view of the fact that the recovery is about 150 kg of contraband, but to see that all the material witnesses in the present case have examined within a period of 4 months. If
trial conclude
within a period of 4 months, 4 months, in the event the trial is not concluded within the said period, the petitioners are given liberty to renew their bail plea after the expiry of 4 months. With this observation. Both the matters.
Both the matters.
4 months material witness. Yes. And so the petitioners move such application for a grant of bail. The claims shall be considered by the trial court on the basis of the material available on record and on its own merit. Yes.
Yes, my lord. Yes, my lord. Permitted to withdraw, my lord.
You withdraw.
26.
Yes.
My lord, permitted for adjournment 15 days.
Why adjournment, sir?
I have not got the instruction from the
adjournment. On request adjournment.
28.
May I please, my lord? Offense under section 273, 274, 275
Yes.
of IPC, my lord. The present petitioner custody since 15/1/24, my lord.
15?
15/1/24.
15/1/24. Okay. Yes.
Yeah, 28. Yes.
Allegation?
Allegation, my lord, seized from the present petitioner 15 bottle of cough syrup.
Hmm?
15 bottle of cough syrup.
Chemical
9,
examination report? Have you got?
CD has not come, my lord. My lord, there is, as according to the order of rejection by the land court below, my lord, there are 10 criminal antecedents.
Oh.
With the same allegation, NDPS also there. And
you call for CD.
My lord, the PDPD already maximum punishment, my lord.
You have 10 criminal antecedents. So
Yes, my lord. My lord, maximum punishment 6 months, my lord. The petitioner already custody 6 months, my lord.
So you intending to continue your profession by coming out. Wait, 10 antecedents. Otherwise you are entitled to bail.
Yes, ma'am.
So let us see the CD. What I've done. Generally, what happens is false cases are being foisted against these people. In one case, you arrest them. All the unsolved case you thrust upon them.
My lord,
That happens some.
may before your lordship, your lordship may direct to the petition council to file a comprehensive affidavit regarding the criminal and
You give your,
Comprehensive
so that I can impose appropriate conditions.
Yes, ma'am.
Yes, ma'am.
Okay, you give your
is
affidavit regarding impeachment, right? And then Mr. Rahul, Learned Counsel of the state submit that the petitioner is having 10 cases against him, and against him the petitioner is directed to file an affidavit detailing the particulars of the cases pending against him, registered and pending against him, registered and pending against him. Call for the sheet, call for the PDO. Okay, least after 2 weeks. Yes. 29. Yes. Pass over. Pass over. He is there already. Okay. Come on. Yes.
Well, here implicated under section 302 IPC along with other offences, my lord. Custody from 2/2/2023, my lord. 2023, my lord.
23. Okay.
My lord, may I
Yes.
submit one thing? My lord, the two seated witnesses.
I am
are there,
submitted
30
to that.
numbers. And among them, all the vital witnesses.
They have not
19
supported.
have,
The
19
vital witness, my
let me
lord.
say,
Let
One
me-
minute. Hey,
19
somebody
I am
speaks,
helping
don't overlap that.
I am helping. 19 PW has already been examined. And most of them, on their chief, they have stated that this somebody X has told that this petitioner has made the extrajudicial confession that he has committed this occurrence, murder. But in fact, at the time of trial, my lord, that so
The only extrajudicial confession is the only
he
evidence
has
against
hostile.
him.
Yes, ma'am.
So
And
the
the-
matter is going to be on the end. So let us.
My lord, nobody that he has not supported. That only basing upon his statement.
That's right, but he says something else.
But,
You will be acquitted. That's what
Well,
he
but
says.
bail stage ଆମେ ଏଠି କରୁଛୁ ଓକିଲ ଟିକେ lordship kindly consider ସେ custody ରହିଲାଣି ନାଇଁ acquit that is separate your lordship
Where are the depositions?
well your lordship kindly see the extrajudicial Mali Mandangi Mali Mandangi
Mali Mandangi.
His statement is my lord.
Where is that?
My lord 16th page 97 my lord.
97.
Yes my lord. He is the person he stated that took alcohol and
PW7, huh?
PW 16 my lord. Page 1997. Mali Mandangi.
67. And what about the other witnesses?
On whose house they were also consuming liquor, my lord, Ghasi Patra. He has also turned hostile. On that particular day, the deceased and that statement is, my lord, PW8.
Confession you tell. So,
And that extrajudicial, my lord, while in the affair also, page 12, my lord.
There is no eyewitness.
No eyewitness. That is the.
But see, I'll grant bail that you will evaporate somewhere. You don't.
No, my lord, any stringent condition, I have no criminal antecedent. I will appear and is date of trial, local man.
Already trial.
No, I am a local man
I'll
also.
tell you if there is no material according to you.
Yes, my lord.
And in fact, there is no material.
Yes, my lord.
If I'll relegate him, he will be acquitted.
Yes, my lord.
Okay. If I'll relegate it, will take another 10, 15, 20 days, whatever.
Yes.
Why the liberty of this man for 10 days, even for 1 day? Even for 1 day. If you know that it will be end up in acquittal. If I send him, it will take at least 10, 15 days. Now, who will give that custody period? 10, 15 days? You tell me.
Yes,
He is entitled, he is entitled.
Yes.
The only thing is you have to make sure that he should be present. For that, I will put stringent condition.
Yes, madam. I am submitting before lordship that the records are.
Liberty of a person for 1 day also makes a big difference. Sentence, we generally pass sentence till rising of the court. That is also a sentence. Liberty is restricted till rising of the court. Just imagine. The liberty is so important right now. The petitioner is also. The education against the petitioner is shown. the trial has also substantially proceeded. About 19 witnesses have been examined. The only allegation against the petitioner, as per the prosecution, is he has extrajudicial confession. Extrajudicial confession. However, the witness to establish extrajudicial confession has been examined as PW 16, who has not supported the case of the prosecution. Apart from that, all the witnesses so far has been examined by the prosecution have not supported the prosecution. In that view of the matter, I am inclined to admit the petitioner on bail. The petitioner is in custody since
2/2/2023.
23. Since the trial is at the fake end, to allay the apprehension of the prosecution that the petitioner cannot appear before the court once he is enlarged on bail, I am intending to impose the following conditions. The petitioner shall appear before the trial court without bail and without seeking any adjournment, and he shall not influence any other witness to be examined by the prosecution. In the event any of the bail conditions are violated by the petitioner, the prosecution is given liberty to move appropriate application for the court below. Recalling the concession of bail granted by the court. If such application is moved by the prosecution, the trial court should decide the application on its own merit. With this observation, the petition is enlarged on the bail. Yes. Next slide.
30.
Yes.
Item number 30, my lord.
Yes.
The petitioner is in custody since 18/12/2023, my lord.
18/12.
Yes, my lord.
Okay.
Initially, the affair was lodged under section 498 capital A, 302, 304B, 34.
Yes.
and
Charge sheet filed.
Charge sheet is submitted, my lord.
306.
306, 498 A,
Show me the allegation.
Pardon, my lord?
Show me the allegation.
Allegations.
26. Your husband.
Yes, my lord, I am husband.
How he has died?
Asphyxia, my lord. By hanging.
Hanging.
Yes, my lord.
Door was bolted from inside.
Door was closed inside.
Closed
from inside.
Show me that port.
That is what not there, my lord. That is not
Show me that
written.
portion.
Yes, sir.
Portion. If the door is bolted from inside, you show me that portion. I will guarantee bail. Have you read it?
Yes, ma'am, that
Monday.
is-
Monday. You read it and come.
Much
Monday.
Case has been charged.
Charge sheet.
Charge sheeted. You only show me that while she committed suicide,
Yes, ma'am.
she had bolted the door from inside.
And that is not written here, my lord, but,
But
as per my
some-
instructions.
Don't go instruction. Read
Yes,
it.
ma'am. Yes, ma'am.
Monday I'm.
My lord, much
Yes.
31.
Yes. Yes, sir.
Dear my lord, the petitioner is in custody since, my lord, 2/1/2024.
124.
My lord, being charge sheeted for the offenses under section 376 and other allied offense, 354A, 354D, 376(2)N.
Foxo is not there.
Also,
Also is there.
Yeah. Well, I'm coming how six is not applicable. Well, here is a case. The victim is aged about 24 years.
Victim.
20?
4
4 years.
Huh?
And she says, as per her
And
case,
the accused is 27 years.
as per her case, she is in relationship since last 7 years. And if the case will be accepted as it is, the relationship started in the year 2016-17.
So therefore, Foxo.
So my lord.
Well, after that, it is alleged that
Read 164.
well, let me see.
164. If they are in relationship, what?
ମୁଁ ବିରୂପ ଭଗବାନଙ୍କର ଶପଥ କରି କହୁଛି ଯେ 2016 ରେ ଯେତେବେଳେ +2 ଆର୍ଟ୍ସ ଏଲଏନ କଲେଜରେ ଆଡମିସନ କଲି this petitioner Madan Mohan Panigrai ମଧ୍ୟ ସେଇ କଲେଜରେ ମୋର କ୍ଲାସମେଟ୍ ଭାବରେ ଜଏନ୍ କରିଥିଲା। ସେଠାରେ ମୋତେ ଫଲୋ କରେ, ମୋତେ ଭଲ ପାଏ ବୋଲି ବାରମ୍ବାର କହୁଥିଲା। ମୁଁ କିନ୍ତୁ ବହୁତ ଥର ତାକୁ ରିଜେକ୍ଟ କରିଛି। ମୁଁ ସେ +2 ସେକେଣ୍ଡ ଇୟର ବର୍ଷ ସେ ନିଜକୁ ସାରଙ୍କୁ କହି ଗୋଟେ ଇକୋନୋମିକ୍ସ ଟ୍ୟୁସନ କ୍ରିଏଟ୍ କଲା। ତାକୁ ସେଠାକୁ ମୋର କିଛି 3-4 ଜଣ ଝିଅ ସାଙ୍ଗ ଓ ସେ ଏକା ପୁଅ ଯାଉଥିଲୁ। ସାର୍ ନଥିଲା ବେଳେ ମଧ୍ୟ ସେ କ୍ଲାସ୍ ଅଛି କି ନାହିଁ ଡାକିଦିଏ ଓ ଲଭ୍ ପ୍ରପୋଜାଲ ଦିଏ। ମୁଁ ମନା କଲେ ପୋଲରୁ ଡେଇଁ ପଡ଼ିବି, ହାତ କାଟିଦେବି। ଥରେ ହୁଡ଼କରୁ ଫେରୁଥିଲା ବେଳେ ଶ୍ମଶାନ ପାଖରେ ଭଲ ପାଏ, ମୁଁ ତତେ ଭଲ ପାଏ ଏବଂ ମୋତେ ବାହା ହେବା ପାଇଁ ଚାହେଁ ବୋଲି କହିଲା। ମୁଁ
ମାଟିଆ ବନ୍ଧର
ନିଛାଟିଆ ରାସ୍ତାରେ ମୁଁ ସକାଳେ ଏକା ଯାଉଥିଲା ବେଳେ ମୋତେ ଜୋର ଜବରଦସ୍ତ ଜାବୁଡ଼ି ଧରି ମୋତେ କିସ୍ କଲା ଓ ବ୍ଲେଡ୍ ବାହାର କରି ତା ସହ ରିଲେସନସିପ ରଖିବା ପାଇଁ କହିଲା। ମୁଁ ଡରିକି ତାକୁ କହିଲି ହଁ କହିଲି। ଥରେ ଭାଲେଣ୍ଟାଇନ୍ ଡେ 2017 ମସିହା ଦିନ
Yes. Custody still?
my lord,
20th yes, Mr. Rao, you want
my lord, 164 statement is there, my lord.
Uh-huh.
Here is also same thing, my lord. Here is 376 2N, 500, 506 and IT Act 60CE and 67A, my lord. And my lord, 164 statement I may be allowed to read.
Last part.
First,
It must be a consensual
Yes,
sex,
ma'am.
thereafter videograph and viral.
Yes, my lord.
This is the story.
But one of a tragic thing has been happened by this accused person, my lord. Whatever may be happened. After that, that victim has got married to another person and living happily. But after that, this petitioner has sent that nude photographs to her husband, my lord.
This is no.
So this is very bad in this society, my lord.
No. You
Now she is getting pain, my lord. What she has deposed here, my lord.
evidence is recorded?
Yes, my lord.
Prosecutory evidence? Prosecutory evidence.
What a 164 statement, my lord.
No, evidence is not recorded.
No.
You renew after the prosecutory statement. And you are sending, you have whatever you have done is one thing. After she got married somehow, and your husband.
It is only problem, my lord.
This is a limit to yes. Please. Evidence about the victim prosecution. Examine. Not in that. Yes.
Petition is inside custody, my lord, 18/11/23, my lord. 376(2N) and 6 of POSCO, my lords. And my lords, already the girl has been already deposited before the court, my lord.
No, what
Denied, my lord.
But sir, everything is right, my lord. But in this victim is minor.
No, at that time 17 years and 4 months. Now he is major. I've given.
Regarding that, any date of birth certificate or
Yes, already 17 years and 4 months, my lord. The time of affair, my lord. And totally denied the girl about the victim, my lord. Report is deposition.
What is the age of this
boy? 23, my lord.
Oh, 23. Currently, petition is accused and thrown. The trial is in progress, and the victim girl has been examined. In the examination in chief, C. Intralia has stated age under para 2. The petitioner is also a young boy, about 22 years old. Whereas victim is stated to be a 17-year-old.
4 months. Now it is 18.
They were in the relationship. The petitioner is not petitioner. The victim is badly treated by her parents. Therefore, voluntarily she left the house of house and started staying with the petitioner. Since the victim is a minor, the FIR is lodged against the petitioner, and the petitioner is facing the trial. petitioner is in custody since 18/11/2020.
23.
The trial is in progress and the victim call has already been examined. Therefore, I am inclined to admit the petitioner on the date. Yes.
May I please, let's see. Let's say I'm in virtual mode, let's see.
Yes.
The date of alleged occurrence 11/2/2023. The 9 months after the FIR is lodged, that is on 8/11/2023. And the FIR is registered 376 and 384. 506
So what are the allegations you tell me?
The allegation is that it's both the alleged victim is a married lady, and this petitioner is, happens to be her relation. And it is alleged on 11/2/2023 when the victim was inside her house, then the petitioner went there and proposed her for that I love you. So she did not reply anything. Thereafter, he sexually ravished her, your lordship, and taken some nude photograph. So this is the FIR allegation. So in the meanwhile, the victim has been examined, and as a PW1, I am supplying the copy of the deposition there, your lordship.
Yes.
The deposition copy of the victim I am supplying, your lordship, a glance.
No, the victim has already been examined.
Yes, my lord. Yes, yes, my lord.
Now she served the copy, man. The deposition copy now he served, man.
Just now served, your lordship. Just now served.
Next week, people, we just see what are the allegations and all.
My allegation is 6-8. For last 8 months, he is keeping relationship with threatening that if you will not keep relationship, then I will viral your nude photos. And subsequently, he has that photos also viral by him. Yes, it was seized, and therefore 66 IT Act is there.
Viral in social media, or he send it to?
Sent to the other relatives' mobile phone.
Mobile phone is seized.
Mobile phone is seized. Photograph also seized.
We'll see next week.
35.
Next week, your lordship. Your lordship, next week.
I just come.
May 2023.
5
May 2023.
Yes.
And offense under section 307, 452, 323, 326, and 325.
307.
Yes, my lord. 307.
Show me the injury.
Injury, there is, in charge sheet, my lord, and page 21, my lord. One is simple and other two are grievous, my lord.
Where? Head.
My lord, simple is on forearm. Grievous injury is on upper abdomen. And another one is on poncho.
What has he used? Knife?
Bhujali was used, and it was also seized, leading to discovery that Bhujali was seized.
But no, the
And he was treated at SCB for last 10 days. After the
10 days.
incident, he was SCB for
Now he's all right.
Now he is well and hearty, my lord.
Out of
What
danger?
is now what is his health condition that
No,
incident?
but when he discharged, was he all right?
Yes,
Discharge time.
And what is the stage?
19 witnesses were there. Charge sheet was submitted on 31/7/2023.
What are the criminal antecedents here?
No criminal antecedents.
Antecedent is not there. Antecedent not there.
He discharged from the hospital.
Discharge from the
And custody since last 1 year, my lord.
1 year. 1 year.
More than 1 year.
307, 1 year. What?
More than 1 year.
Relating to the injury on the abdomen by means of Bhujai. So
he will be convicted.
Luckily he was not safe. Otherwise,
He is not lucky. He is lucky. He is lucky. Anyway, about one year, May
1 year, 2 months.
1 year, 2 months. Trial is proceeding.
And my lord, PW was also examined as PW1, informal.
Trial is going on, na?
Trial is going.
Trial, yes, my
But
trial
it
is.
not my lord, a formal deposition, page 25 has annexed one copy. That is not a formal deposition copy. Otherwise, you have typed that copy and annexed it.
Will be convicted for sure. Because 307 is much more dangerous than 302. Because the victim will come and depose, then he is out, gone. So he is bound to be convicted. So 1.5 years near out he has stayed. Oh, right. Petitioner is accused also. The allegation against the petitioner is the victim in the case has sustained 3 injuries, out of which 2 injuries alleged to be grievous in nature, which caused in the abdomen. The petitioner has used usually to assault the victim. The trial is going on. Trial is going on, and the prosecution witnesses have already been examined. The petition is in custody from 5/5/2023. The trial is likely to take some time. The petitioner has already remained in the custody for about 1 year, 2 months, and the trial is proceeding. Trial is still going on. I am inclined to entertain the bail plea of and regarding to the fact that the petitioner has already undergone for such a period and the trial is already proceeding. He has been, victim has already been examined?
No, my lord.
Injured.
With an additional condition that the petitioner shall not be in contact with the victim in any manner whatsoever. He shall appear before the court without fail on every date of hearing. In the event the petitioner wanting for violation of any of the bail condition imposed by this court, or for that matter the trial court, the prosecution is at liberty to move appropriate application before the court below for the cancellation of the concession of bail granted by this court. If such application is moved, the trial court is at liberty to decide the application on its own merit.
My lord, one condition that he shall appear before the trial court on each day of posting. He shall appear before the trial court on each day of posting.
That I have said.
Yes,
that I have said. Without bail. And he will not seek adjournment unless. Yes, sir.
May I please, Your Lordship? The
Yes.
petitioner, the brother-in-law, Your Lordship, it's a custody since 27.
Yes. What are the offences?
Offense, Your Lordship, charges submitted on section 498, 304B, 306, 34 IPC, Your Lordship.
Your husband?
No, my lord. The petitioner is the younger brother-in-law, Your Lordship. And the custody
What's the
since,
allegation against?
in fact, in the FIR, Your Lordship, there is no allegation. Against the specific allegations against the present petitioner, Your Lordship. And only my implication is that before marriage, some amount transferred to my account, Your Lordship. As per their marriage settlement, Your Lordship, 2,30,000. Only that.
In
Only
the
that.
death of the,
No, my lord. At
what
the
is
time
it?
of death, Your Lordship, myself was at my Ravensa College as a lecturer, and the husband was at bank, and the father-in-law, Your Lordship, he was at market. Your
Hanging.
Lordship. Yes, hanging
locking
inside the locking the door, Your Lordship, and they called to all neighbors and custody since 27/1/2024.
27/1.
2024.
24, Your
Yes,
Lordship.
what do you
Marriage
think?
was
Here, he was claiming money, and money has been transferred after the marriage.
Money, that part was 498 and all, forget it. In 304B. What is his role?
Structure is that to the extent they are demanding money, so that's not the.
He is not husband, he is the brother-in-law.
But he is also involved in it.
Brother-in-law is working as a lecturer.
But he, repeatedly he is asking for money. If he is not a husband and brother-in-law, how he is claiming money?
For that he will be convicted. But what is his role in the death of the deceased?
Only that can be.
Role is that only that demanding of dowry and torturement, and money was transferred to his account. That is only materials.
Nothing.
And father-in-law, mother-in-law, sister allegation about, though
They
allegation.
have been granted anticipated bail subsequently from charge sheet, their name have been recluded.
What about the?
They have shifted
Husband
the
custody.
Custody.
Yes, Lord.
After this, you will
My
apply.
But they have
Parity.
shifted the dead body to the SCB. Some witnesses have stated that they were rescuing the deceased and they were
Shifted to hospital.
I will grant bail to this. And you have option to oppose the husband's bail. Okay. Right. Petitioner is accused.
That's why I'm filing for Kalak.
Petitioner is the brother-in-law of the deceased. The allegation against the petitioner is that he has been party to the demand of dowry, and marriage, a certain amount has been transferred to his account.
By submission, we noted that after marriage also.
After marriage also, this petitioner has been demanding dowry from his sister-in-law and the family members. And the date of the incident when the deceased has committed suicide, the petitioner was not present in the spot, Rather, he was in the college.
Ravensa College.
He was Ravensa College. Ravensa College. He is a lecturer. He is a lecturer in the Ravensa College. The petitioner is already in custody since 27/1/2024. Regarding to the fact that the petitioner is the brother-in-law of the child, and he has no role to play in the commission of insofar as the commission of the death, the alleged death of the deceased is concerned, barring the fact that he has been demanding dowry from the family of the sister-in-law. I'm inclined to enlarge the petitioner on bail with the same condition. He will appear in the court on all this.
Obliged.
37.
Not my name, you recorded.
No, name. Also appeal for the party. Opposed bail, payment.
May I please, Your Honor? This is a case under section 20 of NDPS Act, my lord.
Recovery?
22 kg, 520 gram of ganja.
22
Present-
kg, 500.
Petitioner is a
Custody fund?
23rd, 25/12/2023.
25?
12/2020.
23.
My lord.
And my lord, it belongs to Chhattisgarh, same condition.
Same condition. Outside condition? Grant bail 22 kilo?
520 gram.
520.
520 gram.
520 gram. And custody since
25/12/2023.
And to allay the apprehension of the prosecution, the condition.
Not the outside condition.
Outside, same. 38. Yes.
That, the petitioner is a married lady, my lord, having two children in custody since, my lord, 11/7/23.
11?
11/7/23, my lord.
11/7?
23, my lord.
Yes.
Arrested on 11/7/23.
302.
302, 147, 148, 120B, along with other offences, my lord.
Okay, what are the
Well, allegation that the deceased, my lord, having
is
a
there?
deceased having, my lord, 21 cases of 302 along with other offences, my lord. He along with other co-accused, my lord, other person, my lord, went to the spot where the petitioner's husband was, my lord, he was cultivating a land, and some cattle, my lord, destroyed the land of the husband of the petitioner, and the husband of the petitioner protested, and there is amicable settlement between the deceased and, my lord, the petitioner, the husband, my lord, and thereafter again, my lord, quarrel ensued. The petitioner went to the deceased and called to her house for an amicable settlement between all the families, my lord.
And the husband killed.
Husband, another co-accused, my lord, that Tungi alias Dibos Naik, he killed, he given first blow. Thereafter,
What is her role?
her role, my lord,
Yeah. She has also asserted.
that is the omnibus allegation.
No, she has, leading to discovery that Koturi was seized from the
No,
from the spot.
Hey, she was using Katuri.
No, my lord, no. Hold on,
No,
no.
And my lord, Tenta and Koturi also seized from the spot. Tenta and Koturi, which also seized from the spot. Another Koturi was seized from the present petitioner.
You see the lady, you tell me what is her role.
Yes.
Well, she has asserted.
Eyewitnesses
are there. I'm reading that statement.
Read that part. Read that part.
And the deceased was holding a pistol, my lord. He came to the spot and assaulted her. And this petitioner tried to, my lord, resolve the dispute between both the families, my lord. And all of a sudden, quarrel ensued, and on the
Right. Are you taking a plea of right to private?
that, my lord, he was holding a pistol, my lord. That there is a charge sheet, my lord. That there is the records.
Pistol recovered.
My lord,
Yes,
he
yes.
has 21 numbers of antecedent against the deceased man.
The case of 302 other offenses, my lord.
That's 21.
Read that part.
Yes.
See the lady who let us enlarge him her bail.
My lord, I'm reading one of the member house statement. That
Meghana Naik, no?
ମୋ ପୁତୁରା ଫଡି ଅଣ୍ଡା ନାୟକ କହିଲା ତୁ ମଦ ପିଇକି ଝିଅ ବୋଉଙ୍କୁ ଅଛନ୍ତି ଅଭଦ୍ର କାହିଁକି ହୁଅ ନାହିଁ ୟା ପରେ ଘରକୁ ଯାହା କହି ଠେଲା ଠେଲି ହେଲା ନଣ୍ଡା ଆସିକି ତା ସ୍ତ୍ରୀକୁ କହିଲା କି ଫଡି ତାକୁ ବାଡେଇଲା ମୁଁ ସେଠି ଫଡି ଫଡି ତା ପାଖକୁ ଯାଇ କହିଲା ତୁ କାହିଁ ମୋ ସ୍ୱାମୀକି ବାଡେଇଲୁ ଫଡି ସେଠୁ ଆସିଲା ମୁଁ ତା ସ୍ୱାମୀକୁ ବାଡେଇ ନାହିଁ ସେଠୁ ପୁଷ୍ପ କହିଲା ଯଦି ମୋ ସ୍ୱାମୀ ବାଡେଇଲା ଆସ ପଚାରିବା ଫଡି କୁ ଯିବା ପାଇଁ ମନା କଲି ଆଉ ଫେରିଆସ ପକେଇଲି ସେ ଫେରିଲା ନାହିଁ ସିଧା ତାଙ୍କ ଘରକୁ ଗଲା ତା ସାଙ୍ଗେ ସାଙ୍ଗେ ଟୁଙ୍ଗି ଗୋଟେ କଟୁରୀ ଓ ଫଡି ମୁଣ୍ଡରେ ହାଣିଦେଲା ପୁଅ ଟୁଙ୍ଗି ଘର ମୁହଁରେ ଖସିଗଲା ଖସି ଯେମିତି କୁକୁଳୁ ହାତୀ ଟୁଙ୍ଗି ସବୁ ଫଡି ନେଲେ ଘର ଭିତରକୁ ପୁଣି ମୁଁ ଦୌଡ଼ି ଗଲୁ ଆମକୁ କଟୁରୀ ଧରି ଗୋଡେଇଲା ଆମେ ପଳାଇ ଆସିଲୁ ଟୁଙ୍ଗି ପଡି ତା ମୁଣ୍ଡରେ କଟୁରୀ ମାରିବା ମୁଁ ନିଜ ଆଖିରେ ଦେଖିଛି ଏଇ 5 ଜଣ ଟୁକୁଲୁ ହାଡି ପୁଷ୍ପ ପ୍ରେଜେଣ୍ଟ ଟୁଙ୍ଗି ଆଉ ନଣ୍ଡା ଆମ ପୁଅକୁ ମାରିଦେଲେ
ଟୁଙ୍ଗି କିଏ?
Tungi, my lord, the principal accused, the who was given the first blow.
Puspa was not holding Koturi.
No.
Another eyewitness.
But this eyewitness says Puspa was not holding the Koturi.
Only assaulted, my lord. No weapon of offense was used, my lord.
No.
No. Say you weapon used.
Koturi was Tunga was holding the Koturi. One Koturi is recovered. One Koturi can't be.
No. Say you jagger podi thala. No.
Present petitioner. Another Koturi from the spot, man.
There are two Koturi recovered.
Tenta and Koturi was seized from the spot.
Show me that this lady was holding Koturi.
My lord. On a reading part, they
clarify
Pulu Naik, Prosan Naik, Puspontal Naik, petitioner. Missi, ତାକୁ ତାଙ୍କ ଘର ବାଟ ଅଗଣାକୁ ଟାଣି ନେଲେ ମିଳିତ ଭାବେ ଉକ୍ତ ଲୁହା କଟୁରୀ ଓ ଏକ ଲମ୍ବା ବାଉଁଶ ବାଡ଼ିରେ ଲାଗିଥିବା ଲୁହାର ମୁନିଆ ତେଣ୍ଟ ଦ୍ୱାରା ମୋର ପୁତୁରାକୁ ମିଳିତ ଭାବରେ ଭୁସି ଚାଲିଲେ. That is the injuries is that my lord on the injury on the face and slap. And my lord, another thing is my lord.
What is the stage?
That is submitted, my lord. More than one.
There are two eyewitnesses, huh?
Yes, my lord. There are 3 eyewitnesses, my lord.
4 members of eyewitnesses. And my leading to this that Koturi my lord that seizure was made from the present picture.
ସେଟା ପଡି ଥିଲା ତାକୁ ନେଇକି ତା ଘରେ ତ ରଖିଥିଲା ଲୁଚେଇ ବୋଲି ସେ କହୁଛି 27 କହୁଛି.
But let these eyewitness be examined.
My lord, can similar. So he has not used any weapon, my lord. The weapon who was failed on the ground, my lord. He concealed in a bush. And 27 recovery the weapon of
3 eyewitnesses, they are taking your names.
My lord, they are naming, my lord. I am saying what they are stating, my lord. ଫଳରେ ମୋର ପୁତୁରା ତଳେ ପଡିଯିବା one thing, my lord, ମୋର ବଡ ଭାଇ ଟୁଙ୍ଗି ଦିବସ ନାୟକ ମୋ ପୁଅକୁ ତା ଘର ସାମ୍ନାରେ ଦେଖି ତା ଭାଇ ସହିତ କାହିଁକି ଝଗଡା ଲାଗୁଥିଲା ବୋଲି କହିଲା ହଠାତ୍ ଲୁହା ଲମ୍ବା କୋଟରେ ତା ମୁଣ୍ଡକୁ ହାଣିଲା କି ଟୁଙ୍ଗି ଦିବସ ନାୟକ ଫଳରେ ମୋ ପୁତୁରା ତଳେ ପଡିଯିବାରୁ ଟୁଙ୍ଗି ଦିବସ ନାୟକ ଟୁକୁଲୁ ନାୟକ ସୁଶାନ୍ତ ନାୟକ ପୁଷ୍ପଲତା ନାୟକ ଶକ୍ତି ନାୟକ ମିଶି ମାନେ ଆଣିଲେ.
Death is due to that blow.
Yes.
Head blow.
Head blow.
Head blow is this on the slab.
I know. But death is for what?
Due to head blow,
due to injury on the
medical
face and
report.
flap.
Yes.
Death is due to loss of high function of vital organ.
Vital organ.
Vital organ.
Koturi injury found where?
From the slap, my lord.
That is Tungi has given that.
Yes, Tungi has given the blow, that admittedly. All the statements.
How this lady?
My lord, fast Tungi
The
assaulted.
blow, according to you, you are not certain whether this lady has given a blow or not. If at all she has given blow, corresponding medical you show me.
My lord, fast Tungi has assaulted.
First
Then all are assaulted, leading to discovery Koturi was seized from the present petitioner.
And eyewitnesses stated that all are asserted the deceased.
There are two Koturis or one Koturi?
One is
Recovery
seized from the present petitioner.
Two
Another
Koturi recovered.
Tenta and Koturi was seized from the spot. Another
27 recovery is two or one?
One man. One Koturi. Another was from the spot. Tenta and Koturi was seized from the spot.
Witness, eyewitness.
But actually, he has not assaulted me, Lord. Actually, he had gone for compromise between the parties, my lord. All of Tungi, Dibos like assaulted. An allegation against four others, my lord, they have assaulted, but this petition has not used any.
Eyewitness have taken the
Name of the present petitioner.
and there is two. I could have entertained your bail application if there would have been only one Koturi. There are two Koturi recovered.
No,
And
one was
Koturi Tungi was holding that. That is
yes, that has been
come
recovered.
clear. The other one
Was recovered at the spot, my lord.
Spot.
Yes.
That is by with you. You
No,
were
no, no,
holding
no,
that.
that is not seized
You
by.
were holding that.
Koturi was seized from the present petitioner.
No, no, that can be 201.
Seize is something different. I tell you, seize is something different. Whether she was holding the Koturi
No, nothing.
by time of incident.
No, my lord, that is not there.
No witnesses stated that she has holding Koturi. All are stated that he was assaulted by Tenta and Koturi and other materials. But
That is.
Wait. How much time will you take to examine these witnesses? Eyewitnesses.
My lord, doctor said, but charge sheet was submitted since 4/11/2023.
4/11?
2023.
4/11? I am giving 3 months. Examine this witness.
Two children, my lord, there is no other, all in custody, my lord. Entire family are in custody, my lord. This petitioner and husband, 3 others are in custody, my lord. No one family members there, my lord.
You have
Two children,
also.
2 children, my lord.
What is this?
My lord, the one is 10 years and one is 5 years, my lord.
Where have you seen that?
That time, today morning I acted, my lord, instruction. But because, yes, my lord, she's a married lady, my lord, can see her age, my lord. What is here?
Put it next week and file an affidavit.
Yes, my lord.
Next week, file an affidavit and the evidence. Where are the evidence? That evidence is also you have not filed.
But that evidence, my lord, the charge sheet I will file, my lord. Charge sheet, my lord.
No, you have not filed, sir.
The charge sheet I will file, my lord. The charge sheet, my lord.
Where is that? No charge sheet.
That I will file, my lord.
You file the charge sheet with an affidavit.
My lord.
That there is two
Two children, my lord.
What are they doing?
Yes, my lord.
And what is their age?
Yes, my lord.
Then I will consider. and
Yes,
grant it.
yes, my lord.
Okay. On that ground, I can at least.
My
find out
lord.
something.
Lady.
Interim bail may be considered. If trial was
If I'll give interim bail, petition has to be kept pending. I can't dispose it up.
authorized
Simple.
dispose of with a direction that he shall not come contact with the prosecution witness. That
All these things, let it.
Yes, sir,
Next,
Yes.
Monday, Tuesday, give an affidavit.
Yes. Item 50 and my lord, 60 are the same, my lord. Item 50 and 63 were the same affair.
And 59,
50 and 63, my lord. 50 and 63.
50.
And 63, my
Who
lord.
is main accused?
No, that is where this petitioner's husband, my lord.
Tungi.
No, Deepa, yes, to Tungi, my lord, yes.
Tungi. So that's why first I should reject. Then only
No,
I'll consider me.
Susanta Naik, no. Her husband name is.
You
No, her husband is Susanta Naik, my lord. Sorry, my lord. Susanta.
Tungi.
No.
Tungi.
No. Her husband is
Dibos Naik.
Dibos Naik.
He has the direct allegation.
He is the principal accused, my lord.
Dismiss. 50
Said
dismiss.
with her soon next week.
No, 50 dismiss. If it will be there, I'll reject that also. I'll tell you. This has to be dismissed. I'm going to give bail to that lady, but not to this man.
You also dismiss, my lord, the item 50, my lord.
50 I'll dismiss.
Yes, my lord.
Put it on Monday. The other matter, I'll grant that bail.
66.
63 also other co-accused, my lord.
Other co-accused. Or other co-accused and this both the matters you dismiss.
No, my lord. Other co-accused there is no.
One minute to revive their bail plea after the eyewitnesses are again. Okay?
My lord, actually, item
and
6.
lady, I'm granting bail to that lady. Why to wait? नहीं 38 bail ಇದೆ ಇದಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ
50 and 63, my lord.
And
liberty may be given.
38 लिखो Mr. Rautra submit that the petitioner is
The married woman, my lord.
submit that
Are in custody, my lord.
are in custody in the present case. Petitioner is a lady of what is this? Age?
37 years, my lord.
37
32 years, my lord.
He has 2 children.
Yes, my lord.
And nobody is there to look after the children. And there is no direct allegation against the petitioner. All the three witnesses, so-called eyewitnesses, have only made a general allegation that she had participated in the commission of a
Yes,
crime. Mr. Rautra further submits that that the deceased was a known criminal having 21 antecedent against 21, no? 21 case.
21 including 302.
21 antecedent against him, and including offense under section
302, yes, sir.
On the date of incident, he went to the house of the accused person holding a
Pistol, contraband pistol.
holding a pistol. Therefore, out of and threatened the petitioners to kill them. Regarding had to the fact that the petitioner is in custody since 11/7/2023, and being a lady and she having 2 children, I am inclined to grant the petition on bail with the condition that she appear before the court on each date of hearing and shall not seek adjournment on any ground whatsoever, and she shall not influence the witnesses whatever. Okay.
And item 50 and 60, permitted to
Revive, permitted to withdraw to
revive,
withdraw to revive the bail, renew the bail plea after the
examination
witnesses.
up to the occurrence.
The occurrence are examined, and it is expected that the trial court shall give preference to trial court shall examine the eyewitnesses preferentially over giving preference over the formal witness.
Within 3 months, that will
No,
be.
not 3 months.
Commitment.
We'll see. Next. 39.
But item 46, the petition has been acquitted from the charge, by withdrawn.
46.
46.
I acquitted from the charges, 46. Withdraw.
Published.
Mr. Rautra submits that the petitioner has already been acquitted.
Acquitted.
From the,
Yesterday only acquitted.
Charges. Hence, he wants to see the one. Hence, he says that the
Infructuous.
Published.
May I please? Petitioner is in custody since 2/2/2024.
2/2/24.
24, Miller. And here charge sheet has been filed on 29/5/2024 under section 376(2)(n), 498(a), 294, 506, and 34 of IPC. The victim is aged about 20 years. And the allegations are all consensual in nature. Your Lordship may kindly turn to page 9. 9, Miller. Consensual in nature, and they have resided, and there was a love relationship between the both. 20 years. Charge sheet submitted on 29/5/2024.
And then you clear my charge sheet was submitted on 29/5/2024. Rejection order is 20.
Yes, that I have seen.
Consensual nature.
No, that's right. You are consensual and everything, but you should go to the court of first instance. See, he's sending you is not that I can't decide or you are.
I'm in custody since.
Idea is you have to encourage the trial court also to give bail.
Lordship, it will take.
All the bails we will decide that's what the trial court.
If there will be any age.
That's right. I'll record everything. Still, I'll send it to the trial. I'll record everything.
They will not grant.
But let the trial court also get give bail.
My Lordship may kindly consider.
Encourage the trial court to. Entertain.
Your Lordship can also consider, my Lord, your Lordship.
I can consider. I'm not saying that you are also.
It will delay.
Sometime I'm interested to relegate you to the trial court. Is that the trial court should be important to give bail also.
If there is POXO or any other thing, I will not, my Lord. This is, my Lord, clear case of consent. And here, your Lordship may kindly consider. Your Lordship.
You are 21 years.
21 years is 20 years.
Listener is 21 years, victim is 20 years.
20 years.
Okay. Right on. The petitioner is accused in such. Does he say?
ମାନେ 164 ଯେ ମୁଁ 5 ବର୍ଷ ଧରି relevant
Victim 164 recording. She inter alia stated that she was in relationship with the petitioner, victim, and had they were and she was expecting that the victim petitioner would be marrying her. Accordingly, they contacted sexual relationship continuously. However, despite the intervention of the village gentry for settling the dispute, the petitioner has wriggled out of his promise to marry her. Hence, he has filed the complaint. Petitioner is in custody since 2024. Charge sheet has already been filed. Therefore, the petitioner is entitled to bail. Entitled to bail. Yes.
Made please, Your Lordship. The
Yes.
petitioner is the father-in-law, Your Lordship.
Yes.
Petitioner is in custody since 31/1/2020.
And after investigation, my lord, one more offense has been added to 302 and 34. That is offense under section 201 of IPC, my lord.
Yes. What are the allegations against you?
Allegation against the present petition, nothing, my lord. Whatever the allegation, that is purely against the
Nothing.
husband.
Still there you are in custody.
Yes, my lord. As because only out of suspicion, my lord.
What is the allegation you tell?
My lord,
Nothing.
if your lordship allow me, may I submit some relevant portion of the
Yes.
investigation, my lord?
What is the allegation you tell me?
The allegation that the present petitioner and her husband, they have killed the deceased. That is the allegation. And sole implication of the present petitioner is on the confessional statement of her husband. And the my lord, one that connected matter is that it is a chain matter that the one of the two villagers, they have seen the deceased with the husband of the present petitioner as the last seen theory, my lord. Subsequently, he was died. They have asserted some blood stain.
What are the direct evidence?
Direct, there is nothing, my lord.
Only last seen theory is there.
And-
And the confessional statement of the petitioner's husband that we have killed the deceased.
And the
Co-accused.
Co-accused, husband and wife, my lord. He is the wife. Husband has confessional statement of the husband.
Manju,
And leading to discovery of
this
the
lady, husband is killed. Husband and wife killed.
The last seen theory is that with the deceased was with the present petitioner's husband in his house.
Husband, not
yes, not against.
They are not staying together, husband and
But
wife.
his wife, where will be live then?
And some wooden plank and bricks, it was some seized from leading to discovery. Some
Last in
blood
theory is also not against this lady.
No.
Again, no,
Husband.
against their husband.
No.
And only thing what you are relying upon the confessional statement of co-accused who is the husband.
Again.
Who is the husband. That is
Again.
the only
What
matter.
kind of evidence that is?
Only that materials, nothing.
Right. The petitioner is accused and so. The allegation against the petitioner is that. The prosecution is Mr. Mishra then for the state submits that the deceased was lastly seen with the husband of the petitioner who is the principal accused. And the husband of the petitioner has also confessed before the police. And the state confessional statement of the co-accused is read against the present petitioner. Except the confessional statement of a co-accused person and circumstances. Circumstances, namely last scene of the deceased with the husband of the petitioner. There is no other material apparently coming on record against the petitioner. Regarding to the fact that the petitioner is in custody since 31.
In small lot 28/10/2022, my lord.
28/1/2022.
28/10.
28/10.
28/10/22.
And what is the stage?
My lord, as per to my instruction, my lord, trial has just started.
Trial is likely to take some time. I'm inclined to admit the petitioner on bail. The petitioner, petitioner is a 27-year-old lady. and the wife of the principal. Granted. Yes.
Obviously.
And with the condition that you will keep on appearing and all.
Obviously.
Yes, next.
42. May please, Your Lordships.
Yes.
The petitioner is in custody since 8/2/2024.
8 to
2024.
24.
Lordships.
Offense.
The offense involved is 419, 420, and 6 of the IT Act, Your Lordships. The allegation is like this: that the informant received a phone call from a number, anonymous number, and the person.
It's a complaint case.
No. And the person, believing him that he was a police officer, because the display picture was such, he has transferred rupees 1,34,000 to his account. And after that, he came to know that it was not so, and then the FIR was lost. This is the basic allegation, sum total of it.
My lord, he has mainly targeted the labor contractors, and the unknown FIR was a call to the informant's mobile that we have captured some laborers, and if you will not give me money, then we will book you in criminal cases. He has sent his photo as a police dress. So subsequently on peer, he has sent 1,34,000 to the
informant.
Informant has sent 1,34,000 to the scanner. That's which scan was sent by the present informant. In the investigation is revealed
Present petitioner.
that the
QR
mobile
code.
number.
You send the QR code.
Yes, Your Honor.
You send the QR code.
The QR code was sent to the informant.
mobile to the informant.
With the threatening that if you will not give him, you will be booked in criminal. We will be booked.
And he paid 1 lakh.
1 lakh.
On
Subsequently, that
separate
number was used by the present petitioner. And he has, my lord, 12 numbers of bank account, which is now under verification. Investigation is still going on, my lord.
Oh, going on. Wait.
Not just
My lord, several numbers of account, he has cheated.
since February. Since February, it is there.
How much time will you take to? Because you are.
Your Lordships, everyone has bank.
Celebrity.
Everyone has bank account. Just because I have many
Nowadays,
dozen.
this is very dangerous, you know.
I admit, Your
everybody
Lordships.
is a victim of
Lordships.
this kind of crime. So let the investigation be over.
Then Lordships, we keep it pending. Let it come.
Shall
back.
I keep it pending or give
Lordships, we
liberty?
keep it pending.
No, email to that after charge sheet.
After charge sheet is filed, that's
No, Lordships, we keep it pending. Otherwise, there's no, because it's a Lordships, the FIR is, even though it's an unknown FIR, and I've been in custody for over 7 months now, 8 months. Because
how much time will you take?
That is again.
Why don't you take some time because
I will cooperate with the
The
investigation.
problem is, suppose I'll dispose it up, then you will file charge sheet after 2 years.
No,
And
the period,
he will be
period you will file.
The period is gone.
Preliminary charge sheet will be filed.
End of September.
Period will.
Let it be pending.
Not.
And then Mr. Mr. and counsel for the state submits that investigation is still going on, and the police is likely to file the charge sheet in the present case. Adjourn the matter to.
Lordships, end of August or end of September will be another 2 months. Lordship, let me try my luck by end of August.
September, first week, second week.
Lordships.
By that time, let us see what.
Let us see. Lordships.
And give instruction that at least this will conclude. This way or that way.
What happened, though then verification on bank account details, he has only that investigation getting 12 number. There is much more account number in the name of the present petitioner. And he has, what is his bank transaction details was out from the bank.
For that, Your Lordships, my presence.
Each bank, my lord, he has opened 3 to 4 numbers of account.
For that, my presence is not
People
necessary.
are so clever, you know, you can't catch them, and even if you prosecute them, you can't convict them. They play in such a manner.
Since they're online transaction, Lordships, my presence is not necessary because they've got all the transactions and it's all on record. It's not that I'm going to take away any. There's no cash transactions either ways.
Anyway, let us see.
Lordships.
Yes. 43. Yes. Yes, sir.
May I please, Your Lordship? Before going to the case in hand, I will give a illustration that will explain more so far the fact and the circumstance of this case. X was murdered, Y is the eyewitness, and said that Z fired to the X, resulting death. Ultimately, postmortem report comes forward saying that there is no injury and death was due to sudden heart failure. So this is the case which I am now going to place.
Custody since
61 seater.
Huh?
Seater 61.
No, I am a illustration. I will come to the what are the offense here and why I am stated so for a
custody.
That means my
January 24. January 24. Okay. Let us see the allegation.
Sir, legal to the course of legal 61 items.
376.
I don't know, 61 name what illustration will the book.
He
My
was giving
my
an
saying
illustration to make his case.
yeah, exactly.
You people should learn how things are put. Don't try to advise. Sit down. You sit down. And that is the way the seniors argue. You must learn how the way. It has nothing to do with this case, but he is giving an illustration to make the things easier. Yes.
Exactly.
Right. Yes.
Charge sheet was submitted for commission of offence on section 376 2N 376 516 reduced section 34
Yes.
and 212. So
Straight away come to the allegation. What are the allegations?
Allegation, just a sequence of facts, I will say. The father of the victim noticed the swelling belly of the victim. The victim was taken to a doctor in the month of December 2023, my lord. There, on medical examination, it was found that she was carrying for 8 months. Ultimately, being asked to the victims, she disclosed that the petitioner is responsible for the pregnancy because he assured to marry, and that's why sexual intercourse took place. It is true that the victim, as per the prosecution case, is minor by then. I am not saying that she was major. After what happened, the brother of the victim along with the victim went to the father of the present petitioner and they disclosed that fact.
Where is 164 recorded?
160.
Yes, sir.
Read out that part.
My lord,
He is
she
22
has-
years.
My lord, she has given birth a child. What my lord and senior is trying to impress that DNA report.
Negative.
The son is that the child is not the biological, the present petitioner is not the biological father of the
That is the entire case. That's why
my submission is that, my lord. Here it is not a determination that whether who is the parental authority, we cannot determine in the court, my lord. But whether the rape was committed or not, that was ascertained from the.
No, it was they were in relationship or not.
They were in a relationship. And they were in relationship. Child maybe belongs to any other person, my lord. That is not. But whether the act was committed or not, that rape was committed or not.
So read 164.
Madam,
It's a consensual. She is minor. I understand.
My lord,
But
still
at
now
the same
perhaps-
time, this boy is also 22 years.
My lord, on the-
my lord, just 1 minute before going to the 164, I have filed 4 case laws concerning bail, including the Supreme Court order. That was the question considered by their lordship. If the DNA test negative that the petitioner is the biological father of the born, entire case is to be viewed with suspicion and
At whose instance DNA test was conducted? You have
no, at the instance of the prosecution. During course of investigation charge sheet was submitted, it was kept open and prosecution collected the DNA test and DNA negative.
Doesn't match with the.
My lord.
Does not match.
Then.
And
And
my
that's
submission not that whether the child, whether the act was committed or not.
you
That is
go
my-
to the
Act is
Supreme Court
committed.
judgment.
It's a consensual.
Child may be, my lord, child may be to any other person. But whether the petitioner has committed a rape or not.
It is your case that she has relationship with any other person.
My lord,
Read
No, no,
164.
my lord, 164, that the date of birth is 21/2008 of the
Girls. Girl. The girl.
girl age is 21/2008, my lord.
Then
She was minor at
Mine-
that time.
About
Now
15,
24, my lord,
15,
perhaps she
15
was
years.
also minor.
15 years. Yes.
My lord, I am reading that is a relevant portion.
Yes.
That ମୁଁ ଗତ 1 ବର୍ଷ ତଳେ 10ମ ଶ୍ରେଣୀ ପାସ୍ କରି ଘରେ ଅଛି। ମୁଁ ଯେତେବେଳେ 9ମ ଶ୍ରେଣୀରେ ପଢୁଥିଲି
ଆଜ୍ଞା ସବୁ ଯାକ ସେୟା ଥିଲା all the cases.
When your bail application was rejected, that time rejected by the trial court, whether that time this
Charge sheet was not submitted on that day.
charge sheet was not submitted, then you have to go to the court of first instance, I record it. Because that's what the court, that the Supreme Court says. Supreme Court says that at the time of the bail plea decided by the trial court, the DNA report was not there.
Again, it will take time.
Whatever, that you are.
Otherwise, your lordship may take note of the fact.
I'll record everything.
No, I am not on this point, what your lordship proposes.
Yes.
I am in the fact that your lordship have look into the annexure 3
page 21.
at page 21. How the career of a boy, young boy, is going to be spoiled.
I know, I understand that.
Was a BTech student then, and the course is 2022 to 2025. In the main period, he was behind the bar. So ultimately, it will affect his career. That is my concern. 22 years, and these are the materials which is replaced. And if again it will be go there, it will take time and some other months will be consumed. Ultimately, what will be the fate of the case by the royal court below, I do not know, but it will consume some time.
So I'll allow it. Because this court says that it was not available at the time of rejection of bail. Thereafter, it considers and says that it is a million-dollar question for the prosecution now to address as to who is the biological father of the victim. And it is to be noted that on receipt of DNA report, excluding the accused as a biological father of the child, investigating officer was required to conduct further investigation and to bring real perpetrator to such a crime to book. That's the judgment. So therefore, the Supreme Court goes and grant bail.
I mean, simultaneously, you also would see what is the future of that guy.
That's right, but bail, I'm considering bail. That's the bail, and he's also a young man. What to do? This is the harsh reality. This life of this girl has been spoiled completely. This is the harsh reality. Right. Petitioner is accused after investigation charges have been filed. Petitioner is in custody since 21/1/2004. Mr. Mahapatra and senior counsel has taken me to various documents form part of the charge, including the DNA report. It is the victim who was examined. And the statement of the victim under section 164 has been recorded by the investigator. The victim literally stated that she had while she was in 10th, while she was studying at the 10th standard, she had developed a relationship with the accused person. On the pretext of marrying her, she contacted the physical relationship with the petitioner. Eventually, got pregnant. When the father of the victim saw her protruded baby, he doubted regarding the pregnancy and took her to the hospital. In the and discovered that the petitioner a week before that she is pregnant. She is pregnant. And in the prosecution, in order to ascertain the paternity of the child born out of the relationship, conducted DNA test. Unfortunately, the DNA test has come that the petitioner is not the biological father of the child born from the victim. Senior counsel has relied upon judgment of Bombay High Court in bail also, which matches the facts of the present case. In that case, also, by the DNA test did not corroborate with the prosecution story. Therefore, the court, while granting bail to the petitioner, in that case, inter alia stated in para page 8, in para 5, inter alia stated agent. Para 5 and 6. Para 5 and 6. The senior counsel also relied upon Supreme Court judgment. Which one?
First one here. Page number 2.
Which paragraph?
First paragraph.
relied upon the judgment of the Honorable Supreme Court. Supreme Court judgment of order of the Supreme Court in first item. The Honorable Supreme Court has in India stated as under E pura part phase 2. To buttress the argument, the 11th Senior Council has also another judgment of the Honorable another judgment of Delhi High Court, where in the similar circumstances in similar circumstances the petitioner in that case was enlarged on date on version date. The reported to the court. Next, regarding to the fact that regarding the fact that the prosecution, the statement of the victim under section 164 CRPC doesn't draw corroboration from the DNA report which is obtained by the prosecution, and the fact that the petitioner is already in custody from 21/1/2004. Apart from the fact that the petitioner is a young man pursuing his engineering study, a 22-year-old young man pursuing his engineering study.
October 24, 2024.
Engineering study. I am inclined to admit the petitioner on bail. However, with the following conditions. Condition could be he shall cooperate with the investigation. He shall not be in contact with the victim or his family member in whatever manner whatsoever, and in the and any other condition to be imposed by the trial court. Okay. In the event the petitioner while found violating any of the bail conditions imposed by this court or for that matter the trial court, the prosecution is given liberty to move appropriate application before the trial court seeking the withdrawal of the concession of a bail granted to him. If such application is moved, the court shall consider the same and pass appropriate orders.
May I play another thing, man? If your lordship will target this case, in the meantime, petitioner was wanted bail. And if the trial will be concluded in the meantime, my lord, your lordship may target it that trials will be concluded in a specific period. Otherwise, my lord, what?
1 minute. Then counsel, 1 minute. Then counsel for the state submits that it is a harsh case because the life of the victim girl is spoiled. There is a child. Of the alliance. It would be appropriate that the trial should be expedited in the case. I fully agree with the contention raised by the submission made by the state council. Therefore, direct the trial court to see that the trial is expedited. And conclude preferably within a period of 6 months hence. Yes,
I will thankful to my colleagues. They sought and briefed me. It is not my endeavor, it is there. So credit will go to them.
But it's a very harsh case. It is very painful to see the life of the girl is spoiled. And at the same time, the boy also.
My lord, that order may be communicated to the court below.
Yes, I'll do that.
Definitely, I'm the.
Yes, next. 44.
May I say one thing, my lord? I have another matter. I request your it before leaving the court. I have another
Which item? 61. Bail matter.
Bail matter.
60. What is that? 61. 61. How many bail matters you have listed today? Yes. Yes, sir. What is this?
My lord, this is a case where charge sheet was submitted on section 498A,
Your
302.
husband. Your
Husband, yes, my lord. I will come to the factual aspect, just offenses are
304B, 302.
302B by 34.
You are only accused.
No. Entire family was entangled in this case.
All of them.
Omnibus statement was made. All other accused persons were released on bail. I have filed that those orders of the coordinate bench available in the Annexure 7 series.
44 to 66.
44 to 66.
What
Well,
are they
actually,
against you? How she died?
Died, it is said that asphyxia, there were ligature mark on the neck and the
throttling.
My lord, actually, that file to another law officer, my lord, he is not present.
Okay.
Next week. So, next week. 40.
Your lordship take up
Next week.
next week.
44. Yes.
Custody since 21/9/2021, my lord.
21?
21/9/2021, my lord.
21.
About 3 years, my lord.
23.
21.
21.
My lord. Charge sheet
3 years.
376 2N, 6 of POSCO, my lord, 363, my lord.
Yes. Show me 164. Evidence recorded.
It was examined at PW5.
Case.
Out of 25 witnesses, 12 witnesses have already been examined as on 21/3/2023. So it must have been
No, not end, my lord. 19 years, 17 years, 6 months, my lord. And eloped and fled away and different places.
What is the statement of the girl?
PW5 mail.
PW5.
He has annexed here.
Read it. Yes.
My lord got it.
Yes, read it.
That
That I am the scribal, I know the accused Ritunrana who is standing in the court today. The
use the mic, I can't listen.
occurrence took place on 12/9/21. On that day, in order to attend a marriage function, I had gone to the house of the sister of my father in the village Guwadi. There I developed talking term with the accused. One day the accused had told me to come out my house. While I refused, it threatened me to die and then came out my house. The accused then brought me to the house of one Papu Munda located in village.
I don't know whether you are
Chandra.
reading or singing a song.
I am reading. That file I refused.
I think you are singing a song.
I am reading, man. One day the
read it, break, give a break so I can
One day the accuser called me to come to my house. While I refused, he threatened me to die. I then come out of my house. The accused then brought me to the house of one Papu Munda located in village Chandala Sahi. The accused then married me at Sibo temple at Kiching and applied vermilion on my forehead. But I subsequently came to know that the accused was already married.
Already married.
We said.
What was the age of the girl?
Age is my lord.
17 years, 6
Poco
months.
is there, my lord. His date of birth is
And petitioner is 19 years.
You are married.
19
I
16
only
years.
give bail to the people, young children, those who are involved in this. You are married, you are keeping a relationship with the
No, my wife is not.
expect that bail.
My wife is not with me, Maro. So
Oh, you have to keep it
no,
relationship.
So your wife was not there?
no. She know that, Maro. Thereafter, he says she submitted. We reside in that house for about 2 days during our stay in.
You are married or not?
Yes, she know that fact, Maro. Thereafter, she reside with me.
Her consent, her knowledge has no meaning because she is a minor.
She's a minor and she stated
Yes,
that
both
You should have acted responsibly
Yes, my lord, that
while
is-
keeping relationship with a minor.
They are, my lord, villagers, my lord, 19 years, they are 3 years in custody, my lord.
Have you separated yourself? Your
As-
husband? Yes, for
He
wife.
is not with me, my lord, since last more than 3 years.
Obviously, you
And
are
then I-
in jail, so
and
your wife is not.
And now, my lord, she also victim also married. And now I am in custody 3 years.
Victim married?
Yes, yes.
Victim married, he says victim married.
noted that instruction. I have not that whether victim was married or.
Where from I'll get it, victim married?
There is the instruction, my lord. I have
You
not.
tell me, you are saying I'll grant you bail right now. You show me anything that the victim has already married and settled in life, then I'll grant you bail.
Question certain hai.
Seek instruction. We'll
And
tell
he
you.
may file an affidavit whether the victim was married and where he
No,
has.
no.
has-
Fit a trueness, I will file up. How to?
No, no, but just
Yes.
tell you some, you make some, you are making some statement means you should be responsible. Some, it should come forth. You are already in custody. The problem is he is already in custody from September 2021.
One is 3 years.
And madam, process most of the witnesses they were examined because 12 witnesses examined since 2023.
23. Total witness?
25.
25. 25 witness. 12
Halfway,
examined.
on the halfway,
One
man.
halfway, huh?
21/3/2023. 1.5.
Shall I-
more
shall I
than
target
1.5 years.
Let it take instruction 3 years, my lord.
No, shall I target it for about 6 months and everything will be. CD has come.
Yes, reliance charge sheet there or forensic laboratory report has not come. Because it is set for the.
After 2 weeks?
Yes.
Okay, after 2 weeks. After 2 weeks.
No.
weekly list as item number 14. It's an old matter. Well,
It's
at that point of time, Mr. Rizvi.
It's like getting inside the house and say.
My lord, I understand, and I understand your lordship's board has also increased this week. My lord, I was only saying, my lord, at that point of time, we had spoken to the my lord, Mr. Rizvi, who is appearing for vigilance. It had come this week, month, my lord, but he had said that he needs some time. My lord, I was only praying, my lord, at any time your
Mr.
lordship.
Bhanti, the problem is after lunch, generally the vigilance people are disappearing because they have taken it granted that matter may not reach.
Well, that is why I was hoping, my lord, if your lordship at any time at your lordship convenience, if your lordship puts it as an old matter, it can be.
You please speak to Mr. Rizvi and you be there so that anytime we can, hear it. Okay.
Great,
Please
sir. Great,
speak
sir,
to
and I'll
Rizvi
inform.
before you mention because their presence is also required.
My lord, I had spoken to him yesterday. I had informed him that I'll be mentioning. He said you can do that and let me know what the court says.
Okay, the moment the miscellaneous board is finished, I am ready to take up any matter,
Man, I'll be ready, man. I'll be ready. Grateful, grateful.
Yes. Item 4.
May I please, your lordship?
Yes.
My lord, this is the case where the petitioner is challenged for crossing of the cognizance taken by the London Trial Court, my lord, under section 420, 460, and 471.
What are the allegation? Why crossing?
I come for crossing. I'm maybe having here. The petitioner story is this, my lord. The petitioner was the headmaster serving at Raigada UGP school, my lord. After passing after having crossing 50 years and 20 years of success service, my lord, he sent a notice under section 41 and 42 to get into voluntary retirement, my lord.
So where is the charge sheet? Where have you filed the charge sheet? Show me the charge sheet.
The charge sheet, whether he has received or not, I don't know, my lord.
The cognizance order, you don't know the charge sheet.
Uh,
What are
the-
the allegation you don't
Then
know?
order, he said that the charge sheet has been filed, my lord.
But see, cognizance order when you are challenging, at least the minimum thing what you have to file is the charge sheet. Without charge sheet, how will I assess whether the cognizance is rightly taken or not? Let counsel for the petitioner.
from the document
Place
available.
on record the copy of charge sheet, list the matter. Yes, next. Yes.
So, by when, sir, given time?
He'll give a date. File a copy of charge sheet. Next.
Let it come 2 weeks after then, my lord.
He'll come. 5. No appears. Defects are there. No? Huh? I have no defects, no defects. None appears. This is an application rejected 7/11/2023, section 311 application. The petitioner is agreed by the order dated 7/11/2023, whereby his application under section 300 CRPC for recalling PW 1, 2, 3, and 6 has been rejected. The impugn order indicates that this court has targeted the for the trial within 6 months. 6 months. Therefore, therefore, even after availing the opportunity of cross-examining the said witnesses, the petitioner has moved the instant application for recalling of the witnesses. Therefore, the trial court has rejected the prayer of the petitioner on the ground that it is a ploy for delaying the trial. None appears for the petitioner, even after second call. Therefore, I'm not inclined to entertain this petition. Yes.
Item 10.
Yes. 10. What is this matter? Yes, sir. What is this matter? Discharge.
Vigilance matter is
Again, discharge.
yes.
None appears for the parties in the interest of justice adjourned to September 11.
Item 19.
Meet please, your lordship. Well, the alleged offences are under section 376(1), 354(3), 384, 506 IPC and section 67A of the IT Act. My lord, my first ground before your lordship would be there was previous intimacy between the petitioner and the informant, and there was substantial and, my lord, inordinate delay of 164 days in lodging the affair. My lord, there was
What are the allegations? Come to the allegation.
As per the affair story, the
No, 164. Read out. Read out.
ରିଲିମାଣ୍ଡ ପର୍ସନ ବଂଶୀଧର ପେଟିସନ ମତେ ଘର ଭିତରେ ବସେଇ ରହିଲା ଆଉ ଟିକେ ପରେ ସେମାନେ କଣ କଥା ହେଲେ ଟିକେ ପରେ ଆସିକି କହିଲେ ଛୁଆ ଟିକେ ମୋବାଇଲ ଦେ ମାନେ ଛୁଆ ଭିକ୍ଟିମ ଦେ ସେ ମୋ ମୋବାଇଲ ନେଇଗଲେ ତାପରେ ସୁଇଚ ଅଫ୍ କରିଦେଲେ ତାପରେ ସେ ଆସି କହିଲେ ତୋ ସହ କଥା ଅଛି ଡୋର ବନ୍ଦ କରିଦେଲେ ସେ ମତେ କହିଲା ତୋ ନିଜ ଇଚ୍ଛାରେ ମୋ ସହିତ ମିଶ ଶାରୀରିକ ସମ୍ପର୍କ soon after getting the expert opinion we will provide the same honorable court.
They are unable to provide. Last two months they have.
Medical evidence is when her husband, I delay, madam, said,
Yes,
my friend
yes,
saying that there are delay. Her husband residing Hyderabad, my lord. He threatened, if you disclose this matter to anybody, then I will kill you and your father-in-law, your son and your husband. For that, she remained silent. Married lady, my lord, did not dare to disclose because looking his family background and his prestige of
My lord,
in the
if,
society, my lord.
if
That time, my lord, what happened? When a husband came, my lord, by the time the wife of the petitioner came to know about the incident, my lord, then she quarreled with the victim. And thereafter, the victim about the issue to the husband. When he came back from the Hyderabad, thereafter only a affair lost. And the husband, my lord, did not agree for medical examination. She is a married lady. And looking at his prestige and family background, my lord, she did not agree. My lord.
is there any relationship between them?
yes,
Show me.
my lord, there was previous acquaintance. It is not the first time she has gone to the bank with the petitioner. They used to go to the
Show me that.
affair reveals, my lord, that affair.
You are in custody
Since 15/11/2023, my lord.
15/11.
15th November.
Yes.
And
The petitioner is the president of a
yes,
self-help group, my lord.
The-
The wife of the accused secretary, the
petitioner is not the president, my lord. Wife of the petitioner, wife of the
the format is the president.
president. Wife is the secretary.
And wife of the petitioner is the secretary. And secretary does not know anything about the society, my lord. This petitioner, my lord, doing all this work on behalf of the wife.
There is a counter affair. There is a counter affair annexed to, my lord.
Intimacy developed, my lord. This way, the petitioner, the victim.
Okay, where is the counter? Where is the counter affair?
Counter affair annexed to, my lord. Complaint
Who
case.
filed it?
My lord, the wife of the petitioner.
Wife of the petitioner.
In this petitioner.
Against
The wife of, against the informant and all other person who were coercing the petitioner to not to give the hand loan. They have taken the hand loan from the petitioner.
Once his case, my lord.
Yes, once is
Once his case.
Check the
Complaint
history,
case.
but see, the fact remains that she is a 47-year-old lady.
Lady 47.
He is 50. And,
What offense, counter offense, my lord? That is 423, 41, 320,
Yes, my lord.
560, my lord. I have
There
already,
are many
mentioned
disputed
before,
facts, my lord.
that subsequently, when the wife came to know about it, there was a quarrel, my lord.
What
That
is the
reason,
stage?
my
What
lord,
is the stage?
stage, my lord, the comment case has already been committed, my lord, court of session, my lord. But
Charge has been framed.
I have no instruction after examination of that victim, my lord, maybe. That is every chances of my lord, threatening of the witness as because, my lord, he has earlier occasion threatened.
Both are married, my lord. Both are residing in the same village, and there is a previous intimacy, my lord. And that these are family matters, my lord. They are having running family, and from some quarrel, it has transpired to this extent. Which altogether is false. And the fact remains that there was a loan taken by the victim from the petitioner.
FIR incident happened in
Incident occurred on 30th September 2022.
30th September 22.
My lord, FIR lodged in 13 March 2023. 164 days of delay.
Yeah, that has been explained when my husband came from Hyderabad. After 4 months, I lodged in.
I think right now the petitioner is accused in FIR number 20. The alleged incident had taken place on 9/2022, whereas the FIR was registered after 164 days delay for 13/3 on 31/2022. During investigation, statement of the victim under 164 CRPC was recorded, and in her statement, she has inter alia stated that on the pretext of you took her to bank.
To bank.
On the pretext of
Provide her loan, madam.
Taking the petitioner, taking the victim to bank for providing, for arranging loan for her.
For the that self-help group, my lord.
Self-help loan for her, and the petitioner took the victim to Bhadrak.
No, my lord, Jaleshwar police.
Where he is taken this.
My lord,
Jaleshwar. You people don't find.
Yes, Baleshwar, my lord. Baleshwar.
And rape is taken
At Jaleshwar.
And confined her in a room and committed the crime. and she could not report to the police because her husband was working in Hyderabad. Once the husband came to the village, everything is disclosed, and thereafter the FIR was filed. And then consequently, the petitioner submits that the FIR was only filed when the wife of the regarding the affairs between the victim and the prisoner, and he started quarreling with the victim. Thereafter, the FIR was launched. Since the FIR was
Viral the
huh?
viral the photograph.
And this incident came to light once the petitioner viral the photograph of the victim. The victim could not be, the victim refused to undergo medical test for the reasons that the incident had taken place about days, 164 days before, and the husband of the victim declined to refuse to cooperate for the purpose of medical examination. The petitioner is in custody since 15/11/2023, and the trial is likely to take some time. Therefore, I am inclined to enlarge the petitioner on bail with various conditions, including the condition that he shall not contact with either the victim or the husband of the victim in he shall appear before the court without bail and without seeking adjournment on any pretext. Suppose he paragraph violation of anything.
Grateful. I'm not grateful.
Yes. What is the LLP?
Your Lordship, petitioner is in custody since 28th May of 2023, Lordship. In the meantime, charge sheet is submitted and as per my instructions,
Custody since
28th May
28 May.
2023.
Okay. Yes.
Yeah. Lordship, for the alleged commission of 302/323/449 of IPC.
Yes.
Allegation is that, Lordship, the petitioner and the deceased, they were in law relationship, but somehow it was not appreciated by the parents of the deceased, for which they have discarded the talking term with the petitioner by the deceased. And being frustrated, this petitioner rushed to the house of the deceased and alleged that he has killed the deceased by means of a knife by cutting the throat of the deceased, Lordship. This is the allegation. And as found from, there is no such eyewitness to the point of assault. But the mother, who was the star witness in a way, she says that when the accused rushed to
CD has come.
Yes, sir.
Yes.
when
Are you ready?
Yes.
Yes.
yes,
You have not filed anything except
except that by that time it was not available with me,
The
Lordship.
file must be there with you.
Unfortunately, that was
You
not
drafted the petition and everything. You don't have.
by going through the order.
Some
I will
file
file just yesterday only I received all this. Lordship may permit 7 days. I will file it.
after 1 week.
I will file it all.
At least minimum.
I follow, Lords. By the time it was not
Yes.
there. I will file, but grateful.
Yes.
My lord, the petitioner is in custody since
Yes.
10/10/2023, my lord. My lord, initially the FIR was registered under section 279, 334 of IPC, which is available. Then negligence driving,
Yes.
and
Charge sheet.
thereafter
Charge sheet.
charge sheet has been submitted under section 307 and 279, 338, my lord.
307
My lord.
from
My lord, allegation
from
my
279 to 307.
my lord. Allegation 4 persons are moving through a bolero vehicle and due to negligence driving, the informant made accident, my lord. And his leg has been fractured. And
Two leg has been fractured. Both leg has been fractured, and after it,
Now, what is the story?
accident is there, Lordship.
Accident there. Who was driving the vehicle?
He was driving.
So 307.
307 of injury part only.
Injury maybe whatever. Where is the intention to kill?
No, at the time, he was escaping. He is theft from somewhere. He was escaping.
While
For that
committing
only.
crime,
Yes,
the
yes,
incident.
yes, yes.
After commission, after accident, he might have.
No, that they are also other person where he has committed the theft. They are searching. They are running behind him. For that only he was rushingly when a road was total of rush. He murdered such
Or he
things.
committed the car.
Yes.
When the police chased him and he
Police, not
made,
the people.
chased
Yes,
him and
yes,
he
yes, yes,
met
yes.
with an accident.
Yes.
That's the whole story.
Otherwise, it is 3 years and head injury, that both of the leg. Both of leg, not head injury.
It is 307 in this.
It is there.
Grand Bill. He is in custody since 10/10/2023. Take 49. After a couple of months, and these kind of cases you will find more in the sense because the new act, the police will start registering cases in all wrong provisions.
He also two
When the new
antecedent.
act, the same thing will happen.
That person has also two antecedent.
Antecedent. Yes. 49.
May I please, Your Lordship? In this case, the petitioner is in custody since 22/11/2023.
22/11.
11/2023. And the allegation
23.
against, yes, my lord.
Yes.
And the allegation against the petitioner is 376(1) read with POCSO Act. And in this case, the victim has been examined and
Read out 164 statement. Read out.
Victim has been examined, Your Lordship.
Yes, already examined.
Already examined, and it is in flag D.
Flag B.
Flag D, Your Lordship.
Flag B.
Flag D. And Your Lordship, please give one glance on the deposition of the victim, para number 10 and para number 13.
What is this case against?
Actually, it's denied for the medical examination. No, otherwise 164. What is the FIR story? That's same 161. That is also 164.
No, flag B is flag D. I am not able to find.
Flag D. D for D. Flag D, Your Honor.
D for Delhi.
Yes.
Okay. D for Delhi. Yes. Read the statement. She has already been examined.
The victim examined, and he said that there was no physical relationship between the petitioner and the victim, and she is at the age of 22 years.
Madam, I told you to read the statement.
She cannot.
Don't give commentary. Please read the statement.
The statement, ମୁଁ ପ୍ରେମ କୁମାରକୁ ଭଲ ପାଇ 17/11/23 ତାରିଖ ଦିନ ପାର୍ବତୀପୁରମ୍ ଶିବ ମନ୍ଦିରରେ ବାହା ହୋଇଥିଲୁ। ସେଠାରେ ଆମେ ଦୁହେଁ ବାହା ହେଲା ପରେ ପ୍ରେମ କୁମାର ଦାଦା ଘରେ age is 22 years.
22. Family is not agree for that only this is happening.
Don't tell in abstract. Tell me in detail what is the case.
Actually,
she is able to tell now. I'll have to read everything. And bail matter is if I keep on hearing for 20-30 minutes application, how will I conclude the
Let's say actually they are both are in love. They move over to some other places where after police when search them and they come back and they come to the parents' house. Again, that same things happen, and this is the affair. And 164 statement also. She has said that I am in love with him and we want to marry. And in a temple we have
they married.
Married, yes.
They married.
Yes, in temple.
She was, by that time, she was a minor.
Minor.
Where is there in the allegation of POCSO?
Yes.
Is there?
Yes.
Where is the charge sheet? Show me. Charge sheet, yes. Right. The petition is appealed and so on. After investigation, charge sheet has been filed for
76 2 76 3 also there. So without informant, lordship, 3 there, lordship. 76 3 there.
notice.
Notice.
Notice was not issued.
Notice was issued, but requisites was not insufficient.
No, Your Honor, I have filed the copy. If my learned friend would have wanted, then it may be served.
Due to the non-filing of the requisite.
minute.
Due to the non-filing of the requisite.
You tell that first.
Yes.
Why I am wasting 20 minutes? I waited like this. Right. Since the offense under section 300, 376, 2, na? What is that?
73.
Where is that?
3.
3 is there or not? Just check it up first.
Yes, since RC duty there.
That's it there.
Since the offense is 376 3 is involved, notice was issued to the victim by the coordinated bench of this court. The service of notice is not sufficient due to want of process filed by the to be filed by the 2 weeks time is granted to the petitioner to file the process to effect the service on the respondent, at least after 2 weeks. You file the process, requisites have not been filed. Service has to be completed.
I filed the
First of all, when you argue, first tell these things. Okay, file the requisites immediately. I'm listing it after 2 weeks.
In next week, because he is the petitioner is of 20 years old boy, and
Madam, everything is all right, but since 376 3 is there, you have to serve the requirement of law. Without hearing, without service, I can't allow your bail application.
therefore it may be posted in next week, my lord, because he posted since 1 year. It may be posted in next week.
1 week I am giving you, sir.
Yes.
And after 1 week, your matter will be listed. List it up. And serve through the IO also. Through IO.
Extra copy to the informant
Oblique victim through IO also. Okay. Through IO.
He has to solve another extra copy.
Extra copy you serve. Through IO also we will try to serve. Okay. Okay, next. Yes. Yes.
Wait, please, Lord. On the last occasion, my lord, I saw because there is allegation under section 376(3), and the note
service is
and the noting has come that service has not been effected.
service effect through IO. Give it through IO.
But your lordship may kindly appreciate one thing, my lord.
For appreciation, the she has to come.
My lord, there is no 376 allegation
But
by the victim also.
Charge sheet is fine.
No, my lord, 161 statement. There is no allegation of 376.
No,
But there is a child marriage. But no 376 allegation.
Show me the charge sheet, sir. The charge sheet allegation is made.
Yes, my lord. But I am relying on the 161 statement and 164 statement.
That requirement you have to serve.
Charge sheets there are 3 there.
It is whether it's made out or not, that's a different story altogether. But the fact remains that there is a charge, then you have to serve. Okay.
My lord.
Through IO, huh? Next.
Good.
Service of the notice to the victim, informant, is not sufficient. Requisites to be filed to serve the victim informant through IO. Okay.
2 weeks there.
2 weeks. Yes. No,
A free copy of order.
yes. 52.
Well, 52, I'm in the VC, my lord.
Yes.
The case under section 302, your lordship.
Hmm.
And it was, I see.
Yes.
But I require further time for its scrutiny.
Adjourn on request.
One which, my lord,
We'll see.
53. May please, your lordship.
September end, huh? Whoever is asking adjournment, put it in September. Yes.
302 allegation against the petitioner, my lord. The petition is in custody since 16/4/23. In the meantime, charge sheet has already been submitted and the FIR is completely against unknown person, my lord. But I have been arrested on the basis of the extrajudicial confessional statement of one Ajay Bhue, the co-accused, my lord. Co-accused. No specific allegation against the petitioner.
Yes.
Yes, it is there.
There.
Yes.
Show me what are they? What are the materials against him? Now there are two accused. Dukhanshu Sahu. There are two accused.
Dukhanesh, sir.
And Prasanna Shah.
Prasansa, another accused person is Ajay Bhue. Basing on the statement of Ajay Bhue, I have been implicated in this case.
You have been. Not
My
you.
lord.
yeah.
You
My
have been. Yes.
No, they all four were from the house of the informant. The four may move on the motorcycle and they took the
What is the material?
material there that I am reading the 27 confession statement.
27.
Yes. That Mu Ajay Bhue, Pita Bishan Bhue, Gramo Banal Thana Search and Search.
Leave that. That is
Yeah.
a co-accused confession is one thing.
Yes.
Leading to recovery, that's what you
Yes.
want to say. Apart from that, what you have?
Leading to that only, they have stated that on knife and
Who
a sack.
stated?
The Ajay Bhue stated one statement of the.
Leave that apart.
Yes.
Apart from that, what you have?
My lord, last scene
Yes.
theory is there, my lord. My lord, for the
Last in what is last in these two
Yes,
the
my
two
lord.
petitioners also.
Yes, my lord.
Seen show me what is that?
But no eyewitness to this spot.
Eyewitness
Spot
is
not.
there.
My lord, statement of one Gullasa. May I read, my lord? Statement of one Gullasa. More namo Gulla. ଗ୍ରାମ ବୁଡା
Relevant part, you read the
yes my
relevant
lord
part.
ଆଜି ତାରିଖ 20/4/2023 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟାରେ ଆପଣଙ୍କୁ ଏଇ ମୌଖିକ ବୟାନ ଦେଉଛି ଯେ 15/4/2023 ତାରିଖ ଦିନ ରାତି ପ୍ରାୟ 9 ଘଣ୍ଟା ହବ ବହୁତ ଗରମ ହେଉଥିବାରୁ ମୁଁ ଖାନା ଖାଇସାରି ଆମ ଘର ସାମ୍ନା ପିଣ୍ଡାରେ ବସିଥିଲି ଆମ ଗାଁର ଷ୍ଟ୍ରିଟ୍ ଲାଇଟ୍ ଲାଗି ଅଛି ଗାଁର ପ୍ରସନ୍ନସା ଦୁଃଖାସା ଅଜୟ ଭୁଏ ଆମ ଘର ସାମ୍ନାରେ ଛିଡା ହୋଇଥିଲେ କିଛି ସମୟ ପରେ ମୋ ପୁତୁରା ସାନନ୍ଦ ସା ହୁ ଇଜ ଦ ଡିସିଜ୍ଡ my lord ଘରୁ ବାହାରି ଆସି ପ୍ରସନ୍ନ ସା ଦୁଃଖ ସା ଓ ଅଜୟ ସା ସହ ମିଶି ଆମ ଘର ତଳପଡାକୁ ଯାଇ ଫେରିଲେ ଓ ଭୁଏ ମୁଡା ଆଡକୁ ଗଲେ ଠିକ ସେଇ ସମୟରେ ମୋ ଦେଢ ଶାଶୁ ଆସିଲେ
What is the stage of the trial?
Yes. That part I have to tell them.
Let's see.
my lord here the informant
What is the
is
stage? What is the stage?
my lord trial has not been
Trial has not been
commenced my lord my lord here the informant is aged about 70 years old he is the father of the deceased and deceased was his only son my lord
Seek instruction. What is the stage of the trial? Next. Yes, next. 54. Yes.
376.
Yes. 376.
Well, custody since 9/2/2024.
9 to
2024.
9
Just
to
6 months.
24.
Exactly 6 months.
6 months. You 164. Read.
Yes, he has lost the affair, madam. Herself lost the affair.
Read 164.
I have not the.
Yes.
Read it. Read it.
ମୋ ନାମ ସାଚନ ସାଚ ମୁଁ କହୁଛି ଜଗନ୍ନାଥ ମଣ୍ଡିଆ ଆମ ଗ୍ରାମର ମୋ ସହିତ ପ୍ରେମ ସମ୍ପର୍କ ସ୍ଥାପନ କରି ବିବାହ କରିବାର ମିଛ ପ୍ରତିଶ୍ରୁତି ଦେଇ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲା ମୁଁ ସେଥିପାଇଁ ତାଙ୍କ ଗର୍ଭବତୀ ହୋଇଥିଲି ମୋତେ ଜବରଦସ୍ତି ବଟିକା ଖୁଆଇ
Foxo is not there?
No.
Petitioner is accused and such and such. Investigation is
Thrice pregnancy has been thrice pregnancy has been
whatever.
committed.
And she is not a child. He is not a child. He is 31 year old. What is her age?
22.
Huh?
22.
22. Both of are major.
And
Consent relationship. What to do?
the to manage new parents, let's say he is without
Right, but you can't convict him for 376. material comes, but bail is right. Satisfied. The victim, the statement of the victim under 164 CRPC is recorded. The victim in her statement entry has stated that she had loved the petitioner and while promising to marry her, the petitioner has contacted sexual relationship with him, as a result of which she become pregnant. That's what pregnant?
Yes,
Uh,
thrice.
pregnant. It is alleged that she has become pregnant thrice over. Thrice over. However, the petitioner wriggled out of her promise to get married, therefore the FIR was raised. Petitioner is in custody since the 9/2/2024. Since the victim is a major girl of 22 years, and the petitioner is, you are married or not? Not married? Petitioner is a 31 year old, 31 old, and the relationship between them developed due to their love affairs. I am inclined to grant the petitioner bail. Bail. The petitioner is in custody from 9/2/2024, with the condition that the petitioner shall appear in the court, and that part also violation. Yes, next. 55. Yes. Yes, sir.
Well, I have the instruction to appear in this matter.
Yes, yes, tell me.
The offence is under section 376, my lord, and with allied offences. And the
26, 23, 20, yes. 307 also there.
307, but there is no such injury, my lord. Injuries are simple in nature. But out of
Charge
my
sheet
lord,
filed.
164,
Charge sheet filed?
charge sheet filed. Charge sheet filed, my lord.
Present petitioner took the victim to a house, my lord, committed get physical relationship without his get physical relationship, my lord. Thereafter, my lord, assaulted, my lord, by knife, my lord. He has sustained 9 injuries in his person.
They were not in relationship.
My lord.
They were
My lord, they were in relationship, my
No,
lord.
no,
They were in relationship.
They are working. Present petitioner good faith come the victim to my house, my lord. When he entered in house, my lord, he locked the house, my lord, get physical relationship, my lord. While he tried to rescue, my lord, from his cloth, my lord, he assaulted with by the knife, my lord. He has sustained 9 injuries in his person, my lord.
164 read.
Yes, my lord.
My
ତା
lord, custody
ଘରକୁ
since
ନେଇକି ମତେ ଶାରୀରିକ ସମ୍ପର୍କରେ ବାଧ୍ୟ କରିବାରୁ ମନା କରି ମତେ ମରା ପିଟା କଲେ ଆଉ ଜୀବନରୁ ମାରିଦେବାର ଧମକ ଦେଲେ। ସେ ଜାଗାରୁ ମୁଁ ଦୌଡ଼ି ଆସି ମୋ ଭଉଣୀଙ୍କ ଘରକୁ ପଳାଇ ଆସିଲି। ଉକ୍ତ ଘଟଣାରେ ମୋର ଭାଇ ସନାତନ ଜେନାଙ୍କୁ ଜଣାଇଲି। ଗତ 20/12/23 ତାରିଖ ଦିନ ତାପରେ ସେ ମୁଁ ତାଙ୍କ ଘରକୁ ଯିବା ପରେ ଘରର କବାଟ ବନ୍ଦ କରିଦେଲା। ମୋ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିବା ବାଧ୍ୟ କଲା। ମୁଁ ମନା କରିବାରୁ 57
Withdraw. Yes.
Thank you, Jalaj. Item number 58, my lord. It is a case of 376 and 4 of the POCSO Act. Meanwhile, the police submitted charge sheet under section 363, 376(2) and 376(3).
24. The major offence is 379 2N.
Date January?
29/1/24.
Okay. Offences?
376 2N, the major offence. My glance over my paragraph 1 under the FR. The case was registered on the section 372N.
Information technology is also there. Huh?
My lord.
Yes, sir.
498 is
My
there.
lord.
378.
498 is also there.
Why?
Not wife, your lordship.
498, how?
There-
498 is
498, 376.
My lord.
All are
387 also there.
Your lordship.
And the occurrence took place, my lord. It is very peculiar and
charge sheet filed?
My lord.
Under what provision?
Oh, same offences.
What are the allegations? Why this is a unique?
Allegations are both are two friends.
Hmm.
And once he called the victim to Calcutta, the service place of the petitioner. Both are service holder. He is the PO of Indian Bank. She is also a cashier in some other financial bank. And
This boy is a PO.
my lord, and the victim is also cashier
Yes.
in a bank. And petitioner requested, and keeping her his request, she went to Calcutta. There she remained in the night, and she was there was physical relationship with her.
They are not married.
Then
Subsequently, my lord,
They
this
married.
occurrence took place in the year 2020.
2020. Okay.
Thereafter, marriage had taken place in the year 2023. And this case has been filed on 24.
Lordship, I am for the informant, your Lordship.
What is the story?
The present in the victim, they were friends, your Lordship, from the same school. They had
Whatever. Now,
Now-
in 2020, something happened.
Yes.
He called, had relationship,
yes,
something happened.
some happened.
And that culminated into marriage.
What has happened,
in
your Lordship?
2023.
I filed a
Now 490 everything.
I filed a counter, not counter exactly, affidavit.
You keep on-
Affidavit, your Lordship may kindly bear. There are statements of accounts in which the present victim, she has transferred a huge amount of money for
Don't tell, this is arm twisting then. Extortion, he might have taken the money from you. And by way of implicating him in this case, you are arm twisting to get the money.
What happened lastly, my lord? What happened? Present petitioner came to victim house with another mistress, my lord. My lord, this happened.
I know, this is big story.
But
Very good, you enjoy fighting outside.
But the fact remains, there is transfer of huge amount from the account of the present
He has given me a
victim.
affidavit, my lord, regarding 7,31,000 has been transferred to the account of petitioner. Let him say,
Why don't you pay the money?
My lord, there is transaction. ये भी देइछ ताकू, से भी देइछ ताकू. सब को देइछ दे.
फेरेच
Mention है, फेराइछ.
2 lakh something फेरेच.
So whether
बाकी किसी दे दो ना कहीं.
that will be different. Whether it will attach the provision 376(2).
And he is
You are marrying her. First you have committed rape. Thereafter you married. There you are going with another lady now.
That will be decided at the time of hearing. But whether 498A,
Therefore you deserve to be there in jail.
498 and 372 and can both.
Come pay some money.
My lord,
I'll put it next week and come with some.
Also,
my lord, any direction will be given.
No, I will. In a bail, why should I recovery proceeding or what?
No.
Bail.
I will deposit. I will deposit. With
You
that,
come with some money, you pay, I'll be entitled for bail, I'm telling you. Next week I'll give bail, but pay something.
7 months Island
I'll give bail, I'm saying 1 week.
with a condition.
No. I will not put. Those are condition one should not. This is a rape case condition. Pay money. What is this?
But unless it will mention in the order.
No, I will not. You tell your client that this is the view of the court. 7 lakhs you have taken. 2
No,
lakhs you
that has not been expressed.
whatever you pay something. Whatever.
Something, yes.
Something.
But it should be, my lord, it should be final.
That will be off the record.
My lord, but that's I will pay, he will pay, then that will
on
pay.
affidavit.
Don't get into all these things. You pay something, come out. You are a PO.
But here, my lord,
You have a luxury of enjoying life.
my lord,
Yes.
I may be
Seven.
accused that whether I will pay here in this before this annual court.
Get a draft in the name of the victim,
My lord,
and I'll not record anything. Pay and I will grant you bail.
my lord.
Yes.
7,31,000 is the amount.
Say it and put it up.
62.
Be happy that otherwise I am going to
Right.
Obliged.
give the bail. At least you will get something.
Right.
Yes.
2.
I am keeping it Tuesday.
My lord.
Tuesday. Keep it on Tuesday.
My lord, 61 adjourned next week.
Urgent, not urgent. Yes.
62.
62.
Maybe also. The petitioner is the husband, my lord. Charge sheet announcement.
Yes.
498A, 304B, 306, and 406 and 34 of Indian Penal and 4 DP Act, my lord.
Okay. Custody.
And custody, my lord, 4th October 2023.
I am for the informant.
And it appears from the my lord, the independent witness, due to domestical, this is committed suicide, my lord. To domestic violence.
Suicide by hanging.
Yes, ma'am. Lordship,
What else?
Your
Medical.
Medical postmortem waiting the Visra Miller. I think the Visra report. Visra not uncomplicated.
Let it come.
Matlab Visra matlab in case
Because
of
medical that must be there.
How
waiting.
does Visra report like
Yes.
Often Visra.
One week.
no, there is
Visra.
opinion. There is opinion, my lord. There is.
Visra.
No, Visra.
Visra, I'm saying.
Yes.
Visra not there.
The medical report is not without Visra.
Visra in case of my lord poison, then my lord. In the case of hanging, my lord.
Investigation complete. I'll give you.
Invest complete. Charge sheet submitted.
Let Visra report come. One week after. Okay.
64.
May I please, your Lord?
Visra report, huh?
May I please, your Lord?
Yes.
Now, the petitioners are in custody since 1/8/2023, my lord.
1/8/2023,
my lord.
1/8/23.
Yes, my lord.
Yes.
For the commission of alleged offence under section 20B 2IC, section 25.
Recovery, you tell me.
Recovery, my lord, the prosecution case is that agents were engaged for loading and unloading of contraband ganja.
Recovery.
Recovery 207 kg. My lord, the fact is that charge sheet
Which is inconvenient, you will never answer it. 200 kilos.
207 kg.
207. Custody since.
Custody since 1/8 or more than 1 year.
You, conscious position, it is record from you.
Yes, ma'am.
It is record from you only.
Record not loading and unloading of contraband gun.
Recovered from them.
But the
all
fact,
4 persons are arrested at the spot.
the fact is that my lord, charge sheet submitted.
What is the stage?
Charge sheet 25 से 24 रे file ହେଇଛି.
Trial not commenced, my lord.
ଯଦି charge frame ହେଇଥିବ ନାହିଁ instruction
No,
ନାହିଁ.
not charge not framed. But the fact is that charge sheet submitted against 5 persons. Last occasion, lordship directed to
After material witnesses.
the kingpin was still now absconded, my lord. Mukunda Malik, who is the kingpin of this case, is absconded. They are engaging these persons to loading and unloading of the contraband ganja.
Material witness 6 months. Material witness 6 months. Yes. Next.
Obliged.
May I please, Lord? In both the matters, na?
Both the matters.
Did you follow what I said?
Yes.
Material witness, till the material witnesses are examined, or 6 months, whichever is earlier. You will revive your bill.
My lord, I am for the OP number 2. A case re OP number 2 1 lakh ro demand draft aji submit କରୁଛନ୍ତି ଏଠି ଆଉ 2 ମାସ ସମୟ ଦେଲେ ସେ
What imposed by
5,50,000 to be
that
ଆଜ୍ଞା ସେ ଯେ ପ୍ରେଜେଣ୍ଟ ଅଛନ୍ତି OP number 2 ଏଠି
What's last year study?
1 month.
2 months
At least 2 lakhs out of 5 lakhs.
1 lakh se 1 lakh arrange କରିଛନ୍ତି.
Give 1 lakh rupees first. Draft, na? Just see. Name, everything is all right?
Surjit Naik, informant ko problem hai.
All right. Conditional bail, na?
Yes, my lord.
When was that condition imposed? Where is that condition?
It is at page, my lord. At page 12, my lord, annex 1, my lord. Paragraph 4.
Paragraph 4.
Considering the paragraph 2, my lord has granted to the what is that? He will pay the total amount of rupees 5,50,000, and that was undertaken. He has given as page 13, my lord.
Yes. And now he is in custody.
It's after release, my lord, he is undertaking to pay the amount, but amount has not been paid till date, my lord. Now he's
So
playing.
you file a conciliation.
Yes, my lord. Says the present or something.
Petitioner is granted. Petitioner has already been admitted to bail by this court by order dated 13/3/2024 in bail number 753 of 2024. However, the bail was subject to the condition that the petitioner shall make good the payment of 5 lakh 50,000. And the condition was imposed by this court on the basis of the concession made by the petitioner. despite the fact that the
Accused, my lord, why the accused?
accused petitioner, he was the petitioner.
He is the opposite party here, my lord. Open number two. Open number two.
You are petitioner.
Yes.
Since the opposite party could not comply the condition,
Yes, madam.
the present petition is filed for seeking consideration of the concession of bail. On the last date of hearing, petitioner has requested for some time to comply condition of bail, condition of bail. And today he has got a draft bearing number so and so of 1 lakh rupees.
In the name of son of the informant.
In the name of son of the informant, son of the Mr. Rautrai accept the same and submits that no further time should be granted to him. However, the opposite party submits that he has acute financial difficulty, that about a month's time to arrange the funds. On his undertaking that he would be making payment, remaining amount for 4,50,000 within a period of 2 months.
Yes, yes, sir. No.
Within a period of 2 months, the present petition would dispose of. And the undertaking is taken on record.
It will be pending, it will be valid. If it doesn't pay, then again I have to come.
I don't. In the event, the petitioner, opposite party, fails to make good the payment as within by this court, the petitioner is at liberty to revive this present petition.
Yes, yes, sir.
Dispose of for the not the land, revive for the application.
Yes, sir. For miscase for revival.
Opposite but not two, my lord.
Opposite party number 2. You move our application.
Yes, yes, yes. No.
It is Doroth House.
Say both possession after 3 to 4.
But he must be having some financial difficulty. That may be another reason.
Yes, taken money.
Otherwise, should he face so much?
It is very well and good to take the money, but refund is very
difficult. Very difficult. You know that. Which would just draft particular. Draft particular. No.
Again,
try and give it. 2 months I have given. Okay.
May I please, Your Lordship? A specific
yes.
person, the petitioner.
Questioning?
Like questioning, nahi. Without issuance of notice, without comply the statutory provision of law, the learned court will have granted bail. That is the bail. Because this one court, while they have referred the antecedent bail, this one court directed to serve a copy. No copy has been issued. No notice has been issued.
Copy of what?
Copy of the bail application or the any order in favor of the accused person. The notice is the mandatory. That is the 15A surplus 5. That is the SCST Act. SCST Act. A person, if headmaster has been brutally.
How many accused are there?
He has not been allowed to function his office.
15 accused.
15 accused.
You want cancellation?
The cancellation, that is, my lord, my whole.
I understand. Non-compliance of the statutory provision, bail is granted.
That should
so
be.
Therefore, you want cancellation. I will not. I will impose costs on them. And 15 people are there, you will get good money. 1,000 each.
No, 15 persons.
15 accused persons.
15
everybody will pay 1.
15 A surplus 5 तक comply करना.
I will not cancel. You know that.
नहीं, वो cancellation भी कहूनी. मोर टिके सुना नहीं करी के करथले सर जीता लगा.
Why are you getting for that money? I'll impose costs on them. Isn't it, Mr. Manu? Why to cancel bail?
A headmaster, petitioner is the head.
See, the trial courts nowadays, the trial courts are encouraged to give the bail. You start cancelling, that's very dangerous. Very dangerous. So once trial court exercise
move bail cancel.
Discretion granted bail on technical ground, we should not.
नहीं bail ले मो cancel. मो को तो सुना नहीं करी करता ले कि जसवन. There is no problem.
Then what I'll do is I'll say that let it continue and you will get a hearing.
Well,
the bail will continue, but you will get a hearing. If you can make out a case, it will be cancelled.
Well,
that's what I do.
You cost को impose कर लो.
You can't have both. You can't have. You can't have both. Either you take the cost or go and argue for your satisfaction. But I will not cancel the bail and it will continue.
Continue.
Till you
नहीं, सेटर भी antecedent bail that is the condition. they will be granted bail and notice is to be sent to the informant because the SCST Act is there.
Where is
There
the
are-
anticipatory? Where is that anticipatory? Where is that order?
ନାଇଁ ସେଥିରେ ଲେଖିଛନ୍ତି that is space ଅର୍ଡରଟାର ଖାଲି ଲେଖିଛନ୍ତି 21/7/2000. The case is record portable appearance of the accused person so and so appeared before this court on the strength of summon issued against them by this court. Victim complaint is absent, learned counsel so and so accepted.
Where is the anticipatory bail?
ନାଇଁ anticipatory bail ଲେଖିନାହାନ୍ତି କିଛି.
Order, can you see page number 21?
21.
The record place hearing on bail application. I have heard the learned counsel for the petitioner and learned special public review the case record. Victim is not present. Since the accused persons already availed the
41A. 41. 41A applicable no 3SST Act. 3SST Act charge sheet, 3SST Act FIR 41A.
Petitioner is the informant. You are the informant.
Informant.
Petitioner is the informant in the bill. He is agreed by the order dated 21/7/2023.
My lord. Consequential
Agreed by the order dated 21/7/2023 and 24/1/2024. Passed by the learned district and session come special justice Nuapada in SA case number 17 of 2022, whereby private opposite parties were admitted to bail. Ms. Das, learned counsel for the petitioner, submitted that under the provisions of section 15A subclause 5. While granting bail, the victim was required to be mandatorily heard. However, no notice was issued.
What happened in this case, my lord? One legal point. If they have not on bail or one not extended, but one then
I am writing, let him go. At least he is satisfied that his petition is allowed. No notice was issued to the victim, and the trial court has granted bail by the impugn order.
Any order.
Therefore, the mandatory requirement of law has been violated. In that view of the matter, he seeks to challenge the impugn order and praying for cancellation of the bail. I have perused the provisions of law. I am of the considered view that the trial court should afford an opportunity to the informant. Should have afforded an opportunity before granting bail. However, since the trial court has already granted the bail, it is directed that the trial court should afford an opportunity to the petitioner for hearing the bail plea of the petitioners till the bail plea of the petitioners, bail plea of private respondents, till the bail plea of private respondents are decided afresh, affording an opportunity to the petitioner. The bail already granted to the opposite party shall remain effective. With this observation, the petitioner. It will remain effective. You won't argue. Yes.
Urgent.
Allowed, huh? Petition allowed. Yes.
May I please, your lordship? This application was.
This court is not convenient on the merits of the case or the question of law raised by the petitioner in the present. I am not expressing any opinion. Yes. Next.
May I please, your lordship? In the main application, your lordship, the petitioner had challenged the order of cognizance, your lordship, and considering the same on 10/12/2019, this honorable court was pleased to dispose of this matter by directing the petitioner to surrender and with but the petitioner could not surrender within 15 days.
You want an exchange?
Yes, your lordship.
Where is that order?
That is order number 4 dated 10/12/2019, your lordship.
4.
Yeah, next.
4.
Order, your lordship, is certified copy.
No, this is order number 4.
Yes, order number 4, your lordship.
Trying to pass
In view of the present petitioner is the husband, your lordship, and the victim is the wife and the informant.
application on bail, such and petition is directed to surrender before within 15 days.
15 days, your lordship, but he could not surrender within 15
When
days.
are you going to surrender?
As your lordship may grant me.
2019, 15
Yes,
days.
I have explained in the IA, your lordship, just after COVID, that COVID broke out and
Right. Earlier, the petitioner had approached this court. Now, in this matter only, it is passed.
yes, in this material, I have filed
1427.
one. This is the
IA for extension.
Okay, exchange. Okay, right. IA, this in the criminal miscellaneous petition number 1427/2018. This court by order dated 10/12/2019 had directed the petitioner to surrender within 15 days and move appropriate application for grant of bail. Such application would be moved by the petitioner. They shall be released on bail.
Yes, they shall consider because the petitioner.
The bail was directed to be considered on its merit. For the reasons stated in the application, the petitioners could not appear within the 15 days. Hence, they are seeking extension of time. Extension of time. The application for extension of time is allowed. Petitioners are directed to appear or surrender before the court below. In accordance with the direction of this court, wide order dated 10/12/2019, and seek remedy available to him under law. Surrender appear before the court on or before 31st August.
Obliged.
Yes.
Urgent set.
Yes. 68.
Item 68, may I please your lordship? Madam, my lord, I am praying for the question of the criminal proceedings on the ground that the dispute is entirely civil in nature, my lord. My lord, the dispute arises between two brothers, my lord. The petitioner is the brother of the informant, my lord. And the whole dispute arises because of the ancestral things of their.
Why did you settle?
They have mentioned in paragraph 5. In the Hon'Ble family settlement was taken place between the complainant and petitioners on 28/C/22 regarding settlement allegations. For that, the university issued notice. But his notice could not be served, my lord.
You are appealing.
I'm appearing. That's there in the noting notes.
Why did you settle?
Let's kindly see the FIR.
No, forget about affair. Why don't you settle your family members and
My lord, there
What
was
they
an
have done is,
anticipatory.
what they have done is, while I was ill, they have gone and in connivance with the bank officials, changed my specimen signature and have committed certain forgery in the bank, which an amount of 2 crores odd is owed by them to me. My lords, may kindly see the FIR at page 14. Now,
Anticipatory bail application was filed, through which we have already opted for the mediation for settlement. And my lord, in the mediation, my lord, the settlement could not take place because, my lord.
Then nobody
there's
can
no
help.
scope of settlement, my lord.
My lord, all the allegations are baseless, my lord, that how.
Baseless or not, that will be tested in the trial.
My lord, may call for the case study.
Forgery, me 2 crores and all. Because
Well,
your
all
family
those
member, I should notice that you will settle. You don't want to settle and what to do?
There was a period during which I was ill, I was bedridden. That is the time when petition number 1 and 2 have done this
What
entire.
is the stage now?
My lord, charge has not been submitted, though I have received the, my lord, the.
Investigation is complete.
No, my lord, not received, my lord.
Not complete, my lord. Charge sheet has not been filed.
My lord, may call for the case diary, my lord. My lord, the entire dispute is civil in nature, my lord.
But civil, forgery in the bank and.
My
all
lord,
this
those
thing.
allegations are, my lord, not in the affair, my lord. In the
Madam,
affair, my lord.
see, listen, investigation is going on, so don't press it right now. And after the investigation is over, I will give liberty and approach the court. I will give you that liberty.
My lord, the allegation is for changing of the ownership of the vehicles, my lord.
I
In
don't know,
the-
madam,
in the-
investigation is still going on. How do you know?
My
He
lord-
says something.
Anticipatory bail order also, the bail application of petitioner number 2 was rejected. Petitioner number 1 was directed to deposit 1 lakh before the learned trial court. I have no instructions as to the compliance of the anticipatory bail.
Very
My lord, there was
complicated.
already an
Very complicated. Let counsel for the petitioner seeks to withdraw this petition to raise all the point at the appropriate stage. Shall I write that or you? I will dispose it up with giving a liberty. Will you withdraw or I will dispose it up with giving the same liberty?
my lord, at liberty.
Right. Petitioner is seeking passing of the entire proceeding initiated against him by the opposite party on the ground that this is a purely civil dispute. Investigation is still going on. Allegations are multifarious. Since the investigation is going on, I am not inclined to interfere at this stage. Therefore, the petition is disposed of with the liberty to the petitioner to resort to the remedy available to him under law if cause of action summoned. Yes. I'm grateful.
Oh, bless me.
69, my lord.
Oh, adjourn.
And Murray asked for entry order.
Entry order continue. Adjourn solo. October.
70.
May I please, your lordship? Appearing to virtual mode, lordship.
Yes, madam.
On the last occasion, your lordship directed for Learned Council, Learned State Council to obtain CD, your lordship.
Respondent number 2 served. Opposite party number 2. I issued notice. Issue notice to the newly added opposite party number 2.
Yes, your lordship.
Let's see.
They have not filed the requisite.
You have not filed requisite, madam.
Your lordship, we have filed the requisite. Yes, we have filed the
No,
requisite.
no,
Your
no.
lordship.
You have. That's the office objection.
Noting it there.
We file it. I am giving 1 week.
We have.
Pursuant to the order dated 2/8/2024, the petitioner failed to file the requisite for effecting service on opposite party number 2. 1 week time is granted. Please the matter. Yes. Next.
71.
May I please, your lordship, I am seeking for adjournment any date after 27th of this month.
Adjourned.
Yes, sir.
Bail application, what is? Passing.
Passing.
Yes, madam.
Cognizance order.
No. The order against the order passed by the Hon'Ble Court regarding the number of
Regarding?
antecedent. Number of antecedent.
This order is about.
Anticipatory bail was filed.
Huh?
Anticipatory bail was filed.
Item number
Subject
कितने
to condition that if he has no antecedent, then he shall not be granted bail. If he has antecedent, he shall not be granted bail. So he has filed
More than one antecedent of
bail
similar nature.
application, it was rejected. Against that, he has filed a CRL. He may file for modification.
modification?
No, madam, this is not maintainable.
No, my lord, I want to submit on the point that petitioner has filed a bail application, anticipatory bail application, where the Hon'Ble Court was directed to surrender before the court, and with a direction to the lower court to verify the antecedent against the petitioner.
Modification.
He was released on bail, but the order passed by the learned lower court was erroneous. That's why I am filing this application for quashing of that order.
This is not the proceeding. You have to resort to some other proceeding. Wrong proceeding here.
I can see page 8, my lord. That's all.
Subject to verification of the criminal antecedent.
Antecedent.
And then criminal
The
file the case for correction order, otherwise, I'll traceable application, otherwise.
Petitioner already released on bail in another bail application, sir.
How many antecedents are there?
Sir, as per the order report of the IO, he has one antecedent of similar nature, and including the present case,
The Honorable Lower Court rejected the bail application and stating that in that he has more than one antecedent, including the present one.
Right, I'm giving you the liberty to approach to the right court. You have come to a wrong court. Right on. Petitioner is agreed by the order dated 17/11/2023, whereby the bail application of the petitioner is rejected. It appears from the record that by the order dated 8/9/2023, this court, while allowing the anticipatory bail application being ABPL number 7897 of 2023, allowed granted the
that number is 11992. ABLAPL number.
No, 78997. Page
7897 is the first application.
And the second bail application is 11992, page 14, madam.
14.
Madam.
11992.
That is order dated 31/10/2020.
Well, it is more than one similar case. The impeded proper subject to verification of antecedents. In case more than one similar antecedent is noticed, then petitioner has this order shall not be given effect to so. Right, of course. No, 11999 1199 of 2 of 2023. Enlarge the petitioner on anticipatory bail subject to condition that enlarge directed the petitioner to
My lord, he is
appeal court and he shall be released on bail subject to condition that subject to verification of antecedent and full subject. It is also categorically directed that in case he shall be released on bail in case it is found that he is involved in more than one similar antecedent, the petition, the order shall not be given effect to. It was found from the Leonard Trial Court rejected the bail application on the ground that the petitioner had similar antecedent, similar antecedent. Hence, the present petitioner has filed petition under section 482 CRPC, seeking quashing of the order rejecting the bail application of the petitioner. I'm not inclined to entertain this petition as the petition is in fact not maintainable under as the petitioner has other remedies, as the petitioners have other remedy. And the petition is disposed of with a liberty to the petitioner to reach to the appropriate under law. With this observation, the petition is
72.
Seven two, my lord, copy not served and also defect has not been removed.
Defect not cured?
No.
Hmm?
No.
72, there are two defects.
Authentication fee not paid. Authentication fee not paid. Copy number.
Should I call the 3 working days for the 3 working days, non-APS for the petitioner.
73.
May I please, madam? The petitioner files his application challenging the rejection of under section 227 of a service matter. And under the annexure 3 matter. The Honorable ADJ has rejected the discharge application of the petitioner matter. The only ground of the petitioner is that the 2 cases has been filed for same occurrence matter. Annexure 2 is the affair lodged before Mahila Police Station, Barampur, for commission of offence for 19 annexure 1, annexure page 8 for 19 for 98 506, and thereafter annexure 2 has been registered, has been lodged on 29/10/2019 matter. 498A, 313, 307, 506.
What happened to the first FIR?
First FIR now pending, my lord. Because,
Investigation is going on.
yes, my lord.
And in the second FIR, this
Charge sheet already been
charge sheet
filed.
filed? What happened? Yes, sir.
Yes, my lord.
One FIR is registered in Umor Court police station in 2019 under 498A, 313, 307, 506. And the same again another FIR is in Barampur PS.
First
498,
498. Yes,
313, 307.
No, no, my lord. Your lordship may just have a kindly glance to the FIR, my lord. This petitioner, my lord, petitioner earlier married, my lord, and keeping secret his own identity, and made a relationship with another petitioner, another lady.
Nivedita Haldar.
Yes, my lord.
In the Barampur case, Nivedita Haldar.
Yes, 419 is there. So 419 is there,
Yes,
my
my
lord.
lord. And thereafter, my lord, but then he and blessed a child, and then he get back his own wife prior the married to this informant, my lord, and stayed there.
What is the name of informant in Umor Court?
Informant name is, my lord,
Umor Court.
My lord, that is Nivedita
Nivedita
Haldar.
Haldar.
Nivedita. In second FIR?
My lord, that is Nivedita Haldar.
Same Nivedita.
Oh.
The informant is same. She can't file two 498 case. Somewhere in the Umor Court, somewhere in the. Just look into the papers.
Yes, my lord.
I think Mr. Rahul is not ready. Huh? I'll put it next week. Huh?
Yes, ma'am.
Please get ready. Huh?
Yeah, yes, ma'am.
Let him.
Yes, ma'am. Yes.
Yes.
74. 74 next week, madam. Next week, madam.
Sorry?
Next week, madam.
Yeah.
Copy not served.
Give the copy next week.
Madam.
Next week, not possible, but yes. Huh? Defects are there, you have not cured.
No, ma'am.
Give the copy, yes.
Madam, next week, madam.
Please, your lordship, 75 is also identical with item number 4 today. It is having the same type of case, my lord.
And also copy not served, my lord.
Huh?
Yeah, copy not served.
The copy serving?
No, copy not served, defect not removed 6 and 13.
6 of 13 ର defect ମୁଁ ଦେଖିନି also.
What did I do for item 4?
No, item 2 weeks after ଆସିବ the charge sheet ଟା ମୁଁ ଦେଇନାହିଁ. I have not given the charge sheet.
I will defect cure करना କିଛି करना.
ଏଠାରେ ସେ charge sheet ରହିବ. ଏକା ସାଙ୍ଗରେ ଆସୁ ଦିଟା ଯାକ ଆଉ.
Adjourned. Yes.
2 weeks after
To cure the defects and.
Yes, ma'am.
Yes.
76.
Manner question of criminal proceeding under section 376 2N 313, 323 and 479.
What are the grounds?
Grounds, my lord. Ground he has taken, my lord, that he is submitting that there is no relationship with the informant, my lord. Your lord, running page number petition 4. Para 7.
Who is filed? Brother? Who is saying? Brother? I think I filed nothing. Right of PS for the petitioner in the interest of justice. Least next week, it is made clear that if the petitioner remain unrepresented on the next date of hearing, the same shall be disposed of merits without waiting for the petitioner's case. In absence here, it shall be disposed of in absence of the council. only.
77.
Dispose of.
77 minutes. Wait, please. I just want to withdraw that IA had filed for modification 1406 of 24 minutes.
Withdraw.
Again. I had mentioned that pattern before, my lords. Because of this pending, it is not being, it couldn't be assigned to the roster bench.
Not in my assent. How can I entertain?
I explained that to the learned DR also, my lords. After that, it was listed today, and they've advised me to withdraw this particular modification of my lord's order, which is pending, after which it could be assigned to the roster bench. Only because I had filed that modification application, it could not be released from my lord.
Seat to withdraw the application for modification.
IA number 1406, my lords, of 24.
Lordship, I'm for the informant. Lordship, may I have a glance at the order?
His application he wants to withdraw, let him do it. While.
It'll go before the roster bench.
Yes.
I'm great. Kindly also note maybe assigned to the roster bench as in.
No, I will not. It will be assigned. Why should it?
My lords.
Lordship, my
Convert
presence.
me to DR.
No.
Listing.
No.
Don't convert my jurisdiction.
I apologize. May I apologize.
Lordship, my presence may be noted.
I'm grateful, my lords.
78 I play it will be taken up tomorrow, man. Tomorrow, 78.
Top of the list because this I have mentioned twice. This is the case where the doctor has been acquitted and the attendant is there and he is in death.
But I have gone through the brief, my lord. It's not a simple case, my
Let
lord.
it be. Huh?
Tomorrow. Great.
This is very harsh case. Just see.
It's not that simple as my lord's friend is submitting. It's not that.
I have made it simple. I will also make it simple.
Due to my learned friend's expertise, my lord.
He is taking time to make it complicated.
Yes.
Top of the list.
79.
Yes.
79, I am praying for 2 weeks time on behalf of Mrs. Das. She informed me that she is ill today, therefore prayed for 2 weeks after.
2 weeks time. Against conviction or what are you asking?
Hello, Edwin.
457. Adjourn protocol. 450. On request, huh?
My lord, I'm for the petitioner, my lord. On demand of my mother, last occasion is to file a new cost title for the opposite party number 3. The notice has been written. So I'm unable to file.
Bereavement in the family of petitioner.
My lord, kindly allow me to amend. Because the opposite party number 3 is the
yes, next.
opposite.
81.
The order of cognizance is under stay has been granted and that is continuing, my lord. The stay further proceeding has been stayed by this honorable, my lord.
Yes.
And the interim order is till today. The interim order is till today, my lord.
Interim order was allowed in the year 2018.
Subsequently extended.
And he has challenges the cognizance of the year 2018, man.
Yes.
What are the grounds of challenging cognizance?
The first ground is
you show me the it's a complaint case.
The complaint case.
Show me the complaint and the statement. If it is there, then you have to face it.
Yes.
Why staying it? Show me the complaint.
The complaint petition is page 12, my lord.
Read it.
All the petitioners are the government officials. And for the public interest matters, the 75 families have already been relocated and 50 families are there for relocation. And the head annexer 2, the opposite party number 2 has signed the resolution for his own, he has agreed for relocation. But for construction of a irrigation project and sanctuary, the government project has been interrupted. In the meanwhile, my lords, the petitioner number 2 and 3 have already retired. And the petitioner number 1 and 4 is in service.
What is the allegation against these people?
Allegation means they have threatened to leave the village, the native village, and but by the annexer 2, my lords, that is page 19, my lords.
the petitioner will only, only his own accord, he's agreed to relocate the village and in a non-forest area.
So they were in the forest area.
My lord.
They were to be
Due to dam
relocated.
project, my lord,
Yes,
they
yes.
were.
Yes,
The government officer, what they do?
and I also.
They are performing their duty.
My lord,
Relocation,
I-
all this, the
prepared
heart burning will
note,
be
my
there,
lord.
obviously.
The decision I have already decided.
Then I will extend the interim order red bureau. Interim order to continue, least for disposal after 2-3 weeks. It has to be cost. See, these people were the complainant and villagers were there in a particular area, which is forest area.
My lord.
And the government has taken a decision to relocate them because forest area is to be vacated.
My lord.
And these are the officers.
Yes.
The accused persons are the officers. They've asked them to vacate. And there would be definitely heart burning. But where is the criminality in it?
No, man.
And they were doing their official duty.
Yes.
What
Yes,
to
yes,
do?
my lord.
So it's a very harsh case. Why
No.
should they face the prosecution? In the forest area, these people have established themselves by
The petitioner-
encroaching. And they were relocated by a resolution.
75 families is relocated.
And there is for
And 50 families is there. And the petitioner opposite part now 2 is he has himself admitted I will vacate the village. And what is
You do one thing, you give a short note
I have prepared.
and put it there. After 1 week, I'll hear you. Interim order to continue. Okay, take it. File is there, na?
My lord, one submission, my lord.
Yes.
In 19/4/23, my lord.
Hmm.
This honorable court has stated that a report was called for from the SDJ, my lord. It was
Till that no report has been issued.
that that order portion is not with me.
Yes.
That what report was called for by the
Status report.
The status report be called
From the
trial court.
That has not come. The
Status report
noting
hasn't
is there also in the cause list.
hasn't come.
No, has not come.
Hmm?
No.
So it has to comply. That by the order dated 19/4/2023, a status report was called for from the court of SDJM Korangia on ICC case number 75 with an indication regarding the progress of the case in the absence of interim stay. The operating paragraph of the said direction reads as under. E paragraph let a status report. Last one. It appears that the pursuant to the same order, the report has not come as yet. Therefore, the SDGM Korangia is directed to place a report in compliance to the direction of this court dated 19/4/2022. This is the matter of 2 weeks. An interim order to continue. Yes. 82.
Pardon, my lord. My lord, item 80. Pardon, my lord. One IA is for kindly handle the matter in the lower court below. My time 12 is the charge made it 10. Then my work is not finished.
Which
So
item?
Item
Which
80.
item?
Item
I mean
80.
82. 80 is over. Long way. Yes.
My lord, on 1/10/2016, 1/10/2016, the informant filed a complaint petition against the entire family members. One is just now 89 years. 89 years, all are both petition number 1 and 2 are octogenarian. And that son and daughter. And London magistrate has taken cognizance of offence section 294, 323, 506, 34 IPC, along with section 3 of SC/ST Act.
The complainant is also very senior.
My lord?
Complainant is also senior.
Yes, my lord. He's 62 years. And he's 89, petitioner is 89 years, ailing and in deathbed. My lord, what happened that admittedly there is a civil dispute between the parties. Both are neighbors and adjacent plots, 66 and 65. Both are and there is a civil suit also. CS number 858 of 2014 is pending regarding that demarcation, that boundary dispute. And just now, both filed criminal cases against each other. And Annexure 3, my lord, there is a compromise. They made a compromise and filed a petition in case of Surendra Sethi, the informant. Usi case re, I'm reading it, page 17.
What do you want?
I'm challenging the cognizance order.
Cognizance order, just see the complaint, page para 6. All allegations are there. There was a civil dispute. You wanted to construct a building wall there. Because of while constructing the wall, there was a fight.
My lord.
This is civil dispute is one. Fighting is.
Yes, my lord.
So therefore, the case is filed.
Yes, my lord.
And what is wrong in it?
My lord. Thereafter, it's a case. He filed it in 2016. 1st October 2016.
Right.
And a compromise petition was filed. Compromise petition was filed in Annexure 3, that is in 2017. Wherein it is clearly stated that of late by the intervention of the local gentries and well-wishers of both parties, it has been mutually decided to end all criminal cases, criminal litigations between the parties by your compromise.
Then are you saying that on the ground of settlement is quasi?
Yes, ma'am.
On the basis
You
of
call them.
on the basis of settlement, a judgment was passed into
Yes, my lord.
6 months. That's relating to another case.
My
all the dispute, he says, all dispute between them. Why don't you bring them here?
My lord.
You have settled, bring them. I'll call.
Notice was issued and he is not appearing. Notice was issued and he is not appearing. My lord, on the basis of that, the compromise petition.
If you have settled, what is the question of notice? You bring him here. Notice services.
See,
I'll fix it next week. You bring the complainant, I'll quash it.
No, my lord, they are no more.
Oh, then they're not. They have not.
My lord, here is a. They have taken admit of that compromise petition.
Oh, that time there was a settlement. They said that we are settling all the dispute. On that basis, one FIR is quashed.
One FIR.
And this FIR, they are not cooperating. What to do?
No, my lord, all the cases were pending.
But
all
can you force?
No, my lord.
For them to quash.
On the basis of compromise, one case was acquitted and we didn't place any evidence.
You don't follow me.
That case,
It's a criminal case.
My lord,
if they come forward, then I'll quash it.
My lord,
and if they don't come forward, I can only issue notice. I had issued notice. What to do? You bring them. They are neighbors. The allegations are not much serious allegations.
Man, they have taken advantage of that compromise petition. And again,
can I quash a cognizance order on the basis of some settlement taken place in some other matters?
In that case, it is clear that all the criminal cases pending against each other.
Can I take cognizance of that in this proceeding? Legally? Answer is no. You know that.
My lord, let it.
I will have to only see whether complaint is, what are the allegations made in the complaint, and what is the statement under section 200 and 202 and all, and whether case is made out or not. This is the test. Case is made out, according to me.
Well, 88 years old.
And if you want that it should be passed on the ground of settlement, you have to bring them. Get an affidavit from them or something. How can I quash it like this?
Well, after 2 weeks, it will be taken up so that I will try.
Learned counsel for the petitioner submits that the parties have settled the dispute pursuant to the settlement. To one of the cases between them have already been quashed, and in so far this case is concerned, he will persuade the complainant to file necessary affidavit or presence of the said complainant before this court. Release the matter of yes.
May I proceed, Lord? The petitioners before your lordship seek quashing of the order of cognizance as well as the complaint against them.
Yes.
The complaint under section 138 of the NI Act.
You are accused.
I am added as accused number 2 and 3 in the complaint case.
Ground?
Everyone?
For
Ground is that, first of all, 138 offence is not made out. Secondly, I am clearly excluded under section 27 of the NI Act. The facts are like this. It is alleged in the complaint that accused number 2 and 3 had given a power of attorney to accused number 1. On the basis of the power of attorney, the accused number 1 had allegedly entered into a contract with the complainant to sell a piece of property. Now, for some reasons, the property was not sold, and the accused number 1 returned rupees 50 lakhs through a check which bounced, issued by the accused number 1. That notice under section 138 was issued to accused number 1. It was allegedly accused, also issued to 2 and 3, but they say address insufficient.
You are 2 and 3.
2 and 3. So it was not served on 2 and 3, and the complaint has been.
Admittedly, the check was issued by accused number 1.
Accused number 1.
And got dishonored for whatever reason.
Whatever.
There may be some dealing with
between
that accused with you or whatever. But you can't be prosecuted for 130.
Absolutely,
That's what
absolutely. That is a short case. And
who is appealing?
I am
Yes.
appealing for the opposite partner 2.
In 138, how can you bring vicarious liability? I'm not
fine.
read it. I'll read.
Yes,
Let
that-
me see.
that-
What are the
that-
complaints? Let
yes.
us see the complaint. Your complaint.
I'll just come to it.
Whoever is issued check against him, you can proceed.
In fact,
Not
what
a
has
third
hap-
party.
no, in fact, what has happened? Story is something else.
No, on the story, if you
In fact,
if you say 420, 468 and all, then you can
I-
bring all these things.
I
vicarious
appreciate,
liability
I
and
appreciate,
all.
I appreciate that.
But not in a 138.
I appreciate that, but the two things I want. One is agreement to sale executed by the power of attorney holder, where they have this dent that who are the principals who are given their attorney.
All these
Number
things,
one.
all these things are perfectly all right. Story, but in
No,
a
I'm- I'm
complaint under 138,
I'm
how
coming-
can you?
Yes,
how can you
I'm coming.
prosecute a person who has not issued the check?
I'm
Yes.
coming to it.
Yes.
Authority has been given to that person to go for sale proceeds, everything, including to deal with the property, including deal with the property. I'll place two things, two documents. One is the with us, which the
accused number 1.
accused number 1 has
All
executed.
this thing will not help you, sir. Difficult.
I'm coming to it.
Very difficult.
I'm coming.
You should have filed a consolidated complaint 138. That is also permissible.
I have
138,
filed.
420, 468, whatever.
No, I have filed the complaint.
Cognizance is taken in 138.
No, I have
Where
filed
is your complaint? Just
138. I have filed.
Where is the complaint?
Complaint annexure 1, page 7.
Let's see.
And page 8, page 9, you'll explained only under section 138, read with
That's
section
wrong.
142(1) B of the NI Act.
That's wrong.
That-
Please.
And 27 is a straight bar. 27 of the Negotiable Instrument Act is a bar.
You have filed simpliciter under 138, read with 142.
That's what I have
That's a
filed.
mistake. You should have said read with all IPC offense. Then you could have brought them, and the trial court could have taken cognizance 138 as well as the other offenses.
That that is
That's a
there.
mistake.
I am not disputing that. But question is, if 138 I've invoked and the check has bounced, check authority has been given to that person to sign and grant that check.
To get prosecuted also.
Everything, because those documents, they have not.
Miss your lordship's question.
I'll just.
He took power of attorney to get himself prosecuted for anything.
Everything. The power of attorney and
Sir, it is a
yes.
statute, it is a special statute, it is statutory offence.
Yes.
And within the parameter of the statute, if anything is made out, it's all right.
Yes.
Otherwise, whatever, the story may be correct, 100% correct.
Right.
But you can't prosecute. Fact of the matter is that.
No, but the law is some.
Let us not trouble on this. Do you have any judgment?
Yeah, that's what.
Show
I'm.
me someday.
That's I'm saying. My legal point is it's a collective legal liability. Number one, because the accused number one and the power of the principals are all involved in this. Because lots may see that document itself.
Show me in the complaint where have you said?
Yeah.
Collective legal liability.
No, that I've stated in my.
No, I will have to read the complaint.
I've read it.
I'll have to read the complaint. Don't
That's
improve your
right.
case in this proceeding.
Yes.
In the complaint, whether 138 is made out or not, that's the question.
Yes.
You show me a collective legally enforceable debt.
Yes.
You show me and substantiate that.
This is
There is no averment in the complaint that
Then
I have
you-
received the
then-
money also.
Very difficult, sir.
Yes, I'll just place it.
Which paragraph?
I'll just place it.
And you give all narration of the story. What had happened, why the check was issued, for what purpose the check was issued, and all these things you have narrated. But where have you said that and see, insofar as you come to 11, you have a worst case in the 11, just para 11 of your complaint.
Then
You
also
say that you have issued notice and statutory notice.
Yeah.
That is written and address insufficient. Even then, case is
138.
more worse.
Address is,
Let us rest it here. I'll pass it.
address is insufficient. Or return with address insufficient because the wrong.
I don't know. The legal requirement is in 138. You have to serve the notice.
Yes, that part.
Even that count also it goes.
Roman 9 will also say. I have said the accused persons.
No, that's not.
I've said the accused persons.
Even you see, you know the law.
Yeah.
If in a company, suppose you don't implement the company, you say, or all directors,
Yes.
accused persons have done it, then also 138 is not maintained.
You lost it. I told
The only thing is, whoever is prosecuting the complaint, he is not well advised to draft it. He could have done something.
Right.
At that stage. Today you can't do anything.
Only question is, my point of contention is.
Give a file written submission along with what
a-
judgment.
Yeah.
Highlighting the judgment.
Yeah.
I am reserving the judgment.
Yes.
Okay, next.
My note is ready. Should I hand it over?
I have ready with the note. I have ready with the note.
You give a written note.
Yes.
I need not waste much time there.
Yes, I have. And I can, these judgments are there.
Give the judgment and write down your name and underline.
I have done.
Which portion?
Yeah, I have mentioned
Write
everything.
down that your name also at the top. I should know that who has cited which judgment.
Okay. On the
At least if
I'll do it.
then I'll get thoroughly confused while
Yes,
dictating.
yes.
Yes. Next. 84. Yes.
So we are for the opposite party.
Victims, my lord.
Who is the petitioner?
But petitioner appearing, my lords.
This is Quasing.
It's crossing, my lord.
Passing.
The charge sheet is already filed, my lords. So cause of action doesn't survive at all.
UW.
EOW. Its trial is also going on, my lord.
Builder.
No, my lords. It's an NBFC company, my lords. They've defrauded for close to 300 crores. They borrowed a lot of money from
and they siphoned it off from their own pocket money.
Not in Odisha, throughout India.
Throughout India. It's close to
Throughout India, yes.
8 antecedents are there.
Is there any stay?
No much. No stay. No interim order. He's still in custody also.
The bail has been rejected by this Honorable Court, giving him.
So where is the question of who is the lawyer? Why quashing?
It's filed long back, man. It's
Long
come
back,
after.
they have filed it.
It's come after 2.5 years, man.
None appeals for the petitioner. The petition is pending since 2022 for quashing of 45 much. By that time, charge sheet was filed.
Not.
By the time the petition was filed, charge sheet was not filed. Investigation was going on. Now the charge sheet has been filed. It is informed by the learned counsel for the opposite party. Opposite party informed this court that charge sheet has now been filed. Therefore, nothing survives in this matter. I'm not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to the respect to the remedy available to him under law.
Well, it's appearing for the informant and for the victim. There are well, it's appearing.
Mr. Pradhan's name, your name, write down and give for whom you are appearing, so that none of it for petitioner. Dispose of. Yes. 85.
85.
Yes.
An affidavit has been filed on behalf of our client. There's a dispute between two brothers. Civil suit was also there. They have amicably settled it, including this criminal case also.
Very good.
My learned friend is appearing for the rival brothers.
My lord, copy of that affidavit has been served on me, but I have to from my client.
Day after? Monday?
Monday.
Parties have settled. आपको तो top पर लगे दो. Parties have settled that dispute. So the petitioner and the opposite party, opposite party
number 2
are the brothers. Real brothers. They have settled that dispute. This matter.
Monday.
Verify it and pass it.
86. Okay. The only arm twisting method. The bank, instead of filing the civil suit to recover the money, has filed the complaint.
Bank file.
Bank. And for the accused.
You're taking loan.
Taken. And that day, no, the law is settled.
But you have taken loan by using false document.
No problem. There is no such.
That must be the allegation.
No, that is not there. Your lordship called upon to furnish the agreement. The agreement does not contemplate that if a payment is not made, criminal case has to file. It is the only way. It is a civil dispute.
Who is for bank? You are for bank.
My lord, that is not the case. I am the owner. Admittedly, if you do not follow the agreement, you have committed a fault as per the breach and the conditions. And I am the owner and you don't even return the vehicle. That by the orders of this honorable court, he has produced the vehicle. As on date, there is outstanding. And my vehicle, I cannot have it to sell to my security interest is being destroyed. A clear case of forgery is made out. A clear case of cheating is made out. And we had filed the case. Your lordship, the cognizance has been taken. He has to stand trial. There's nothing wrong in it. My lord, this honorable.
If there was a contractual obligation.
Says,
comply.
My lord, I am the owner.
Can you prosecute?
Yes, my lord, why not?
Compliance of contract.
My lord, it is deliberate on their part and that has to be tested at trial. If there was a deliberate intention to deceive the bank from the inception, that is a matter of trial that cannot be decided at this stage. My lord, what we say, admittedly, we are the persons who have given the loan. Admittedly, they have taken the loan. They have purchased a vehicle. Admittedly, they are not returning the vehicle. The vehicle belongs to me. As long as they would have paid the money after the hypothecation period, it would have gone to them. That has not happened. They have produced the vehicle even today before the IIC Keunjhar.
What is the story?
My lord, the story is they have taken the loan.
What is the story?
My lord, the story's loan has been taken. They have not
Again, for the purpose of purchasing vehicle.
Your lordship.
Your allegation is the loan is disbursed.
Loan is
they
disbursed.
Have not purchased the vehicle.
They have purchased the vehicle.
Purchased the vehicle.
Yes.
Contract is completed.
Contract is completed.
Okay,
As per the contract, I am the owner.
Now Payment was supposed to be made to you.
Payment was supposed to be made.
They could not make the payment.
They could not make the payment. In the event they could not make the payment, they should supposed to return back the vehicle. I am entitled to the vehicle so that my security interest is protected. They refuse to do that.
What is that allegation?
There is that allegation. Your Lordship may kindly see the agreement. Your Lordship may first kindly see.
So therefore you file a complaint that.
Yes, I am the owner of the vehicle. Admittedly, there is no dispute about that. He is using it till the time he does not make the full and final payment in last penny. As per the agreement, the Honorable Apex Court in Magna Fincor case has already held that I, as the financier, am the owner till the entire last penny is paid.
Where is the vehicle?
The vehicle is with him, still date not returning.
Not that.
Yes.
Kindly see the order. Already the vehicle that was directed. Your Lordship, kindly see the order. The back history, Lordship.
What is the amount?
As on date, Your Lordship.
18 lakhs was loan was given, and he has already paid about 12 lakhs he has paid, and the interest accruing thereafter.
My Lord, there is
And
nothing
Your
that.
Lordship, kindly see the first order. My Lord, Lordship, kindly go through it.
Yes.
First, kindly see the order.
Have you returned the vehicle or not?
No.
Vehicle as per the direction of this Honorable Court. Kindly see the order of the Honorable Justice Mahapatra.
Yes.
That order. That is there. The vehicle, to ensure that vehicle is there, that is why direction was given.
So that was given into.
Yes. Was
IAC.
And that was also as per the order, was given in his
The
Jima.
bank.
Yes, that was given. So it is there.
My Lord, who is the owner? My Lord, I am the owner. My
It is a
vehicle admit.
hypothetical case.
Yes, that means that
Hypothetical
hypothecation is
outstanding.
My Lord, as on December 2022, the outstanding is 10,42,952.
With interest. Why don't you do OT?
My Lord, why doesn't he pay?
OTS you do.
Why doesn't he pay?
Yes. And see,
Yes, Your Lordship. I bow down, my Lord. Bow down.
There is no criminality as such, in true sense.
My Lord,
But
that-
technically you are trying to make out a
Yes.
case, that's a different story.
Your Lordship.
And 12 lakhs they have already paid. Vehicle they have already given.
Vehicle they have not given.
Vehicle they have given. What
No,
is
no,
the
no.
court direction?
No, my Lord, they
There
have.
is a direction of the court. What are you talking?
Please, no, they have not given. I'm sorry.
IAC they have given.
Lord and
They
Government
have
Council has
produced-
given the document that
My
it
Lord,
is
they have
produced.
produced the vehicle. That
So,
possession is illegal.
Say all these things. By the order, by this court's order,
Yes.
they have given it to IAC.
No, my Lord, they have taken back the vehicle. They
What
have
you
pro-
say?
My Lord, may
This is
kindly see.
record, government-
My Lord, may kindly
Anyway,
see.
that I will sort out.
My Lord, may
Give
kindly
the
see.
document.
My Lord-
We sort it out.
Yes,
that,
Your Lordship.
that part. We'll find out. But the fact is, there is a direction to give it to the IAC. They have given it. That's what their story. Written, taken back or not, that is
No, they have produced the vehicle. Your Lordship may kindly appreciate. They have produced the vehicle. They have modified the orders by Justice
Why
Mahapatra.
to go for OTS?
My Lord, we don't have a problem.
You are
Let,
bank, you are into the.
my Lord, we have no problems. Let them
OTS.
approach. My Lord, we don't
You
stand.
have a cheating and you return the vehicle and don't insist for that 10 lakh rupees.
My Lord, let that is the bank's consideration, Your Lordship. I
If the
will make it.
OTS is there,
Huh.
no question of returning the vehicle. Because,
Whatever OTS,
because
work
that
out.
is that is
You
his
work
livelihood.
out. You work out.
That
Go,
can-
go and have a.
As you please, my Lord, I bow down.
If the OTS proposal is given, they can.
No, they
consider
have to
that.
put the proposal, my Lord. We have to
Shall I
accept.
record it? The petitioner, I will not record. Rather, you go and do it. I'll put it next week.
Yeah.
You come with a OTS proposal. You
One
come
ca-
with a OTS proposal.
One week after pare, 8 week pare aro.
Are we rakho? You come with a OTS proposal. Give it to me. I'll give it to them and
OTS ro
I'll not record anything.
OTS रो किसी अच्छी format.
नहीं सर, सिर्फ जहाँ देवे तो 10% approximate
You give a OTS proposal.
10%
And give it to and he will give it to the bank and
Yes, all right.
That's the best way of doing it.
Your Lordship.
I will put it next week, Tuesday or Wednesday.
1 week after करो.
Before I forget. That's
Again?
what I'm saying. Before I forget this thing.
ନାଇଁ ଆପଣଙ୍କର ମନେ ଅଛି ସେଦିନ ଶୁଣିଥିଲେ ବହୁତ ଦିନ ତଳେ
ନାଇଁ ମୁଁ ଭୁଲି ଯାଇଥିଲି but I now understand.
vehicle with the
Vehicle is with the petitioner, my Lord.
If they pay 18 lakhs loan, 12 lakhs they have paid, lot of interest now.
Yes.
If the principal amount with little interest they will pay, they'll retain the vehicle. The bank is not interested to settle
Yes,
the
yes,
sale.
yes.
The
My
bank
lord,
is interested in
principal
money.
outstanding is 10,42,952. Principal outstanding.
Give a OTS proposal.
ठीक है.
Shall I record it?
Record how? Yes, yes.
Mr. Mohanty, the senior counsel, appearing for the petitioner on instruction of the briefing counsel, submits that his client would give a OTS proposal to the informant bank. If such OTS proposal is submitted to the informant bank, the bank shall consider the proposal for compartment proposal as per the guidelines and inform to the petitioner.
My lord, let them deposit some amount. I am not saying any amount. Whatever your lordship decides, 10 lakh is the outstanding.
I'll tell you, if you will accept the
my lord, for
1 minute, you will accept the OTS, you know the OTS system.
yes,
Yes.
they have
And
to
deposit.
pay and
So,
give a
OTS,
person.
you have not accepted the OTS, how they'll deposit?
No, my lord, to consider the OTS application, they have to pay 10%.
That is, for consideration, why should they consider your legal? Under court direction, you have to consider.
As your lordship pleases.
No question of paying anything.
As
And
your
you
lordship.
accept it, then you can fix the installment.
My lord, I will not stand in the way of your lordship's order, but my lord, this pay a 10% upfront amount for the consideration. I bow down, my lord.
Standard practice is also this, that the bank should not litigate in criminal cases to the what you call your customers like this. This is also standard practice. You are supposed to do something else. On the court direction, you have to consider it.
As your lordship
Consider it,
pleases.
place the report here.
Your lordship pleases.
Lordship
And you should be interested in your money. Why
Yes,
you
your lordship.
unnecessarily?
Your lordship.
Lordship putting it to
You give the proposal, the report will be filed here. I'll accept the report and pass it. Okay.
Your lordship.
You get your money back and finish.
Your lordship.
Lordship kindly post it to
1 week after.
1 week after.
Get
Interim order may continue.
Entry mode to continue.
Quebec को रोक
And I tell you, I advise your client to give a genuine OTS.
Right.
Don't say that I'll pay 1 lakh rupees.
Right, सेमती हेल्प करते हो. Bank has to public money after all.
Public money.
Quebec को रोक चलते हैं. Yes, my lord is kindly not keep it on 16th, my lord.
ठीक है. 16 आगे करो.
20-21 जब रोक चलते रोक.
20.
We commence plan. I'm grateful, your lordship.
87.
Yes.
Yes, my lord. The FIR was lodged prior to coming into force of the OPID Act. So, my lords, obviously, the Act cannot have retrospective application. That is the main ground of challenge. I pray it come up on some other day because actually Mrs. Tripathi.
Any other time.
No, I give, but what is he saying?
What non senior saying, my lord.
Offense has taken place at particular time. That time the law was not there.
I understood, my lord. I'll go with Hon'Ble High Court, my lord. These are the economic offense are the continuing offense, my lord. Though, my lord, he cannot take that leave, my lord. I'll show, my lord.
Okay, then. So, fix it, huh? On request. Yeah. 88.
Yes, a week after. Well, next week I won't.
88 also you have appealed.
88, yes, my lords. 88 here, my lords, if your lordship remembers, just a brief recapitulation. My lords, a person was working as a contractor in Jammu and Kashmir. Now he comes home after he decided after 2 months, and then after 7 months the FIR is lodged, alleging that it was, my lords, they have abetted the employees of that company, which was in Jammu and Kashmir, have abetted this
Some
suicide.
elder brother was involved.
Yes, my lords, the younger brother, the elder brother has lodged the FIR.
Last occasion, the lordship directed my senior friend, my lord, that to take instruction what amount you will pay.
My lords, there is no amount outstanding.
Yeah.
We have acquired.
The allegation.
was that some amount is outstanding. Nothing specific has been given. My lords, thing is, my lords, he dies after 7 months. This FIR is lodged, and they are the employees of the company. Nothing, my lords. That, my lords, there is no, my lords, evidence on record to show that how they have abetted this suicide. Your lordships have held
amount was dues were pending. Since they were not paid to me, my lord, she committed suicide with the deceased, my lord. That's why your lordship, the last occasion directed my lord to take instruction. Orally, your lordship directed.
Lordships had asked me, and I had asked my clients, my lords, whether any amount is due, if it can be settled. They said nothing is due. In fact, rather.
How can you substantiate a case under 306?
If your lordship heard the matter, since my lord, a case was registered, my lord, against them, that was ended with the final report. Thereafter, I have filed a protest petition. Cognizance was taken. That cognizance is under challenge, my lord.
That's right.
Initially, they had lodged an FIR.
I know.
FIR ended up in a final report.
Your lordship knows how the final report was submitted, my lord. Thereafter, my lord, cognizance was taken by giving the evidence to not to inquiry. Cognizance was taken, my lord.
And to not to inquiry, your lordships have gone through that, my lord, statement also. Nothing has been uttered against these people. Just there are dues, so he was under depression. My lords, we also get into depression, my lords. That means we'll commit suicide.
Your lordship keep it to,
no, my lords,
1 week after, my lord. Your lordship had the matter, my lord.
4 days.
But see, I have seen the.
I'll give a written note.
Even see, your elder brother was working.
No, both brothers were working, my lord.
And he's the
Therefore, you commit suicide. And the company
your lordship had the matter, my lord. Your lordship keep it to 1 week after, had and finally disposed of.
The top proposed. So, next week.
Next week,
next week I'll also. At the top.
306.
There is a judgment, my lord, by this honorable courts also.
Recently, I have given a judgment. You just see. 306.
Yes, my lord. I've gone through that. I'll also place it before your lordship.
This is a hard case. You can't make out a 306. Something else you could have done.
My lords, the other case also that was quashed, if your lordship remembers, Hon'Ble Goswami's. My lords, there also the allegations were that the chartered, that the architect had not received sums from him. So, my lords, he committed suicide. He was arrested, of course. But later on, the Supreme Court quashed it. If someone doesn't pay, then there's a civil court available.
Off the record, I must tell you, one of the senior counsel couple of days called me and said that your state is owing so much of money to me. And you have been now elevated, payment is not made, what to do?
That's it.
I said, sir, you do one thing, you file a writ petition. What to do? I can't help it. And if that senior commits suicide, then I will also be in accused.
Same story.
I had engaged him, and the state is not paying.
Difficult case. We got bail
Your
for a
lordship, keep
particular.
it to-
We got bail for a particular person.
Then you can give latest. Please put it. 22nd.
22nd, top
at
of
2
the
o'clock. At 2 o'clock.
2 o'clock. Interim order may continue. Well, just recently we got a bail in a very difficult case, my lords. So the brother of the accused had engaged us. So my associate rang him, "Bhai, paisa patra kahin pathana na, mo bhai sangre au paduni."
This is the reality of life. What to do?
I
89.
My lord, 95 may come up tomorrow on board.
It will remain. Whatever remains, that will continue. I'll try to see till 4:30 how much I can. Yes.
89, my lord, I am. My
Same
frame is for the opposite party. It will take some time, can be taken, but at the end of the day now. Now, no casting. That is 126, 2 application has been rejected on the grounds of limitation. can be taken up any date, my lord, in the next week. Next, sorry, 1 week after.
It's pending since
2024, 23, sorry.
anything survives.
Yes, survey. Because final order was already been challenged in the review. Review is pending. That's why.
Chalo, okay. Yes. Next.
90.
My lord, it is after 17.
No, he'll be 17. No.
20.
Before that, not problem. Yes. Yes. Sir.
My lord.
Yes, sir.
My lord, here the interlocutory order impugned before this honorable court is arises out of 147 CRPC, my lord, pending before the ADCP, my lord. The opposite parties, private opposite parties appeared, my lord, but last 2 dates they are not appearing, my lord. My humble submission is I will prepare a short written note, my lord. The final date may be fixed, final disposal, my lord.
Opposite party, there are 12 opposite parties.
Yes, my lord. Notice is sufficient. They have appeared by
Party.
order dated.
Might a kind of glance his prayer, my lord, to recall the PW1 document given from his side, my lord. He is praying, my lord. PW1 may be recalled, my lord. If that will be recalled, my lord, entire case will be disposed of, my lord.
No, I didn't follow it.
His prayer, my lord, to recall the PW1 so that he will adduce evidence in this matter, my lord.
PW1.
Yes.
Himself.
Who is PW1?
The person filed the CMC case, my lord. First party.
The petitioner here.
Here is the petitioner, the PW1.
I couldn't follow. I'm so sorry.
My lord, so petitioner
I'm not able to catch what you are.
No, my lord. Petitioner is a PW1, my lord.
Yes. You are the PW1.
My lord.
And 311 application was moved to recall you.
My lord, yes, my lord. My lord, that was rejected, my lord. That's why I'm before your lordship, my lord.
You want to go?
Pardon, my lord?
You want to be examined?
Yes, my lord. Again, my lord, and I will give some documents, my lord, because.
Why are you so interested? You are the witness?
Yes, my lord. Why? Because in this 147 proceeding, the ADCP has relied upon a where there is no piece of breaches there, my lord. So, my lord, my humble submission is, my lord, here the sub-inspector ASI who had submitted the report 27 months back, he had demanded money from me. I have made a complaint before the vigilance. He was trapped. My lord, that's why I am again, my lord, I am saying that I press inquiry.
You are a witness.
Yes,
you are
my
a witness. An application under 311 was moved, which was rejected.
Yes, my lord.
What locus standi you have to challenge that order?
My lord, my humble submission, I will prepare a
No, you tell me, I'm maintaining that. This is I think you want to achieve something else by.
No, nothing, my lord.
What interest you have? You are a witness.
No,
After all, you are a witness.
My lord, I have.
It is a intrastate dispute between the complainant and.
I am the complainant there, my lord.
Where?
That CMC 147 proceeding.
In that case, not
yes.
in this case. Not in this case where you are a witness.
No, here, that CMC, I am the complainant.
You say that you are a witness.
I'm PW1, my lord.
I don't know where.
No, he is CMC, my lord. Kindly have a glance. My lord, page 47, annexure 6. Kindly have a glance.
Annexure?
6, page 47.
47, okay. Come to annexure 6, okay.
Para 3, my lord, here, stated, my lord. It is appropriate to mention here that during the pendency of the present proceeding, that means that CMC 306, my lord, the Pahada police.
Where are you, sir?
Para 3, my lord.
Page 47.
47.
Again.
Annexure 6.
The first party member is having no.
Yes, first having no witness to examine in the case from this side, but during pendency of the above proceeding, a subsequent event having been occurred, there are some documented evidence which are very much important for the adjudication of this case. Therefore, the same are to be tendered into from this side, from his side. This is appropriate to mention here that during the pendency of the present proceeding, the Pahada police having submitting PR for initiation procedure on section 107 has stated above the ill feeling between the parties. He is saying, my lord, between the petitioner and the opposite party, there is a ill feeling. Due to, my lord, they have they have, my lord, take some government land, my lord, they have encroached, my lord. So it is very, he cannot go from his house to out because encroach the government land. in front of his house. This is the case. So he want to adduce some evidence that there is a chances of breach of peace. But police give evidence, give inquiry report, there is no chance of breach of peace. So that's why he wants, my lord, he may be recall.
He CMC in the CMC case.
My lord,
Yes.
He Sanjeev
Patri.
Patri.
My lord. So he wants to he wants to be recalled in his case, my lord, to give further evidence, my lord. It is total. This is total case, my lord.
What is the order?
Yes, my lord. The impugned order.
Annexure 8, page 69.
Okay.
Page 69.
What are the reasoning?
Or in order, my lord.
Yes.
So far, petition number etiki third para is not
Third para.
third. Says 18/7/23 third para, my lord. So far, petitioner dated etiki for the first party praying not to accept the inquiry report dated 17/4/21 and for fresh inquiry report has got no legal force at all when there is no convincing reason to ignore the inquiry report dated so and so, peruse the said petition along with its reply filed by second party serial number so and so. Inquiry report dated etiki and free from ambiguity, same cannot be ignoring in eye of law. So police report is there is no breach of peace. He is saying that there is breach of peace. So I want to examine myself that there is a breach of peace.
In several other proceedings,
That is only.
the other ASIs had given that there is breach of peace. If there is no breach of peace, how the ADCP will proceed with that 147 proceeding, my lord?
The life of 147 proceeding
It is still pending, my lord. Last it was listed on.
might have been ended by now.
It was last listed on 15 and now posted to 14/8, my lord.
So this is for limited period. How many?
That they are pending. Then, my lord, what, my lord? My lord, kindly have a glance to the
And
order.
if order is passed, that is also for only 6 months.
Order date is impugned 18/7/2023. Which report he had relied? 4/7/2021. 29 months back he had report he had.
Now there is no breach of peace.
Yes, there is breach of peace
Even
because
today continues.
yes, my lord, it continues because they are constructed the
One
wall.
opportunity.
Millard. This was
Let
it.
us give one opportunity and finish.
Millard.
My lord,
Yes.
Petitioner is
I will oblige, my
Millard.
lord.
This is the informant in CMC
my lord.
number 306 of 2021 initiated by him under section 147 CRPC. He moved an application being, where is that application you have shown me? Where is that application you have shown me?
CMC number.
Where is that application you have shown me just now? 6. The petitioner moved an application dated
Annexure 7, my lord.
22/2/2023 inter alia seeking for his recall as a PW1 to mark a certain document to exhibit that the peace and tranquility in the area is being breached by the private opposite parties. The said application has been turned down by the court below, by order impugned order dated 18/7/2023, inter alia stating as under para 69, page 69, para 2. So far as the petition and so on. First, okay. Without going into the controversy in detail, I am for the considered view that the trial court should afford one more opportunity to the petitioner to by recalling him to depose before it and exhibit necessary document. It is made clear that the court below should which court? Additional DCP. They are known as what? Executive magistrate? Or
Yes, ma'am. That is DCP cum executive magistrate Bhubaneswar.
Magistrate. The magistrate should afford a single opportunity to the present petitioner to examine himself as PW1 and tender whatever document relevant to the proceeding. It is relevant to proceeding. Despite service, none appears for the opposite parties.
They have appealed.
private opposite party.
They have appeared, my lord, through Wakalat.
Today, none appears for the
Good, my
opposite party, although here, although this is allowed. Yes.
Dispute.
Okay.
Please, Your Lordship. Item number 91 on behalf of Mr. Saw, I am praying for adjournment. Please not well, my lord.
What is this matter?
About
138 NI Act, madam.
NI Act.
NI Act, madam.
Check him out.
18
lakhs.
You are accused.
Yes, madam.
I am for OP number 2, my lord.
Passing.
No, no, no.
Then what are you asking?
Setting aside of that order.
Setting aside of what?
13/9/2023 order, Your Lordship.
They have challenged the cognizance order, my lord.
What cognizance? 138.
My
What
lord.
we get? 138 no cognizance order. You have to pay the money. You have to pay the money. That's all. Tell for whom you are asking. 138 you have to pay the money. That's all. Yes.
Lordship, item, next I have two items, 92, 93.
92, 93.
Lordship,
It will remain in the board.
No, Lordship, only I pray, Lordship, let it be on Monday, but can it be top of the list so that I am voting since Lordship last 2 years? Lordship, because it is freezing up account, Lordship, so only Lordship
This
can
is arising
take
out of
maximum 10 minutes, Lordship.
457.
450, against order 457, Lordship.
10 minutes for you. I don't
No, Lordship, I'll conclude, Lordship, I'll conclude. I'll only cite the law, Lordship.
You will start citing.
No, Lordship.
judgment,
Lordship, I'm giving a resolution statement. I'll conclude the argument within very.
Let it be there tomorrow. I'll take it up.
Two more, Lordship. Can you top up the list, Lordship?
Not top of list. I'll take it because tomorrow.
Then
Friday.
Monday, Lordship, say, Lordship, top of the list.
No, let it be there tomorrow. You please come at 3:30. I'll see
Lordship,
that
grateful.
tomorrow. If I can't take up, then we'll see.
Lordship, grateful.
My lord,
I'll try to take up.
Item number
grateful.
95, Your Lordship.
Yes.
That vigilance matter, we conclude our submission, Your Lordship.
Let it be there. Be ready. Tomorrow it may reach.
Miller.
I'll retain the board. Subsequently, let it be there.
Miller.
I'll